Senate will come to order for this Monday, February 1st, 2021. Roll call, please, Madam Chief Clerk.
Roll call for Monday, February 1st. Senator Anderson, absent. Senator Baldwin.
Here.
Senator Beitman. Excused.
Excused.
Boner.
Here.
Bouchard.
Here.
Case.
Present.
Cooper.
Here.
Driscoll.
Here.
Ellis.
Present.
French.
Here.
Murphy.
Here.
Guru.
Here.
Hicks.
Here.
Hutchings.
Here.
James.
Here.
Ginsky.
Here.
Kolb.
Here.
Cost.
Here.
Landon.
Here.
McCune.
Here.
Nethercott.
Here.
Pappas.
Here.
Perkins.
Here.
Rothfuss.
Here.
Salazar.
Here.
Schuler.
Here.
Scott.
Here.
Steinmetz.
Here.
Wasserberger.
Here.
And President Dockstetter.
Here. Prayer by
28 present, 1 excused, 1 absent.
Thank you. Prayer by Vice President Hicks.
Members of the body, I would ask you today to keep our colleague and friend, Senator Beitman, in your prayers. He was transmitted to the hospital today, and he's dealing with a pretty severe case of COVID. But members of the Senate, today, I ran across this weekend, and I want to share the scripture out of the book of Exodus with you. Now listen to me. I will give you counsel, and God be with you. You be the people's representative before God, and you bring the disputes before God. Then teach them the statutes and the laws, and make known to them the way in which they are to walk and the work they are to do. Furthermore, you shall select out of all the people able men who fear God, men of truth, those who hate dishonest gain, and you shall place these over them as leaders of thousands, of hundreds, of 50s, and of 10s. Our forefathers understood these scriptures in the Bible, and in doing so gave us a republican form of government. Thus, we at our own making elect leaders at the local, state, county, and federal levels. Exodus 8:21 established a constitutional republic. With ancient Israel, God gave them verses to choose their leaders only after he first gave them the framework of laws to govern their nation. So too is it in America. Our Constitution, based on God's higher law, that the founders titled the laws of nature and nature's God, which they also described as the moral law, is the framework to govern our nation. It is a law higher than any elected official, and a law to which every citizen and government represents must conform. Father in heaven, we understand as elected leaders that we have a greater responsibility to govern with an acknowledgement that the highest law of all laws is your laws. We pray for assistance and guidance in fulfilling our elected responsibilities. We do this in Jesus' name, amen.
Senator Bouchard, would you start us off on the pledge?
Of the United States of America,
which stands one nation.
Thank you. Members of the Senate, at one point here in just a moment, we are going to just preface this, stand at ease for a moment while we look for some more clarification on the correct script to make sure that we do this right. But in the meantime, we'll have messages from the House. Madam Chief Clerk.
Mr. President, did you want to dispense with the journal report?
Yes. Oh, I apologize. Skipped right over it. Chief Clerk, please read the journal report.
Mr. President, your Journal Committee reports that the Journal of January 29th, 2021 has been read and recommends that it be approved. John Kolb, Chairman.
Thank you. Now, Madam Chief Clerk, messages from the House.
Messages from the House of Representatives. Message number 115, third reading passed. The bills listed below passed the House on third reading by the vote indicated. House Bill 25, Tribal Vehicle Registration Exemption Implementation. Ayes 44, noes 16. House Bill 15, message number 115, February 1st, 2021. House Bill 15, Department of Transportation Communications Facilities, ayes 60. Sincerely, Wendy Harding, House Chief Clerk. House of Representatives, third reading passed, amended, February 1st, 2021. Mr. President, the bills listed below passed the House on third reading and in amended form by the vote indicated. House Bill number 4, Mental Health Professionals Practice Amendments, ayes 60. Message number 116, House Bill 53, Invasive Plant Species, ayes 58, noes 2. Message number 118, House Bill 18, Military Training Memorials, ayes 46, noes 14. And message number 119, House Bill 30, Public Utility Assessment,
I'm just sitting here.
ayes 39, noes 21.
Thank you. I'm going to ask for your patience and have the Senate stand at ease until the sound of the gavel. We are just waiting for some clarifying script before we move into the rules segment of this. So just stand at ease for a moment, please. Senate will please resume. Just a moment. Thank you. Mr. Majority Floor Leader. You're on mute. Mr. Floor Leader, you're on mute.
Mr. President, I move that the Senate amend the temporary joint rules of the Senate and House of Representatives for the 66th legislature by amending Joint Rule 11-3 to require adoption of the permanent rules of the 66th legislature until the 12th day of the legislative session, which is currently scheduled for March 3rd. The reason we're doing this, members, is to give us more time for the House and Senate to collaborate together to update the rules together. And leadership encourages a yes vote.
You have heard the motion. A vote of 2/3 of the elected members is required for adoption of the motion. All those in favor, please raise your hand.
Mr. President,
Madam Chief Clerk.
On a 2/3 vote, we traditionally do a roll call.
Oh, please proceed with a roll call. Thank you.
Anderson, absent. Baldwin?
Aye.
Aye. Beitman, excused. Boner?
Aye.
Bouchard?
No.
No. Case?
Aye.
Aye. Cooper?
Aye.
Aye. Driscoll?
Aye.
Aye. Ellis?
Aye.
Aye. French?
No.
No. Furphy?
Aye.
Aye. Guru?
Aye.
Aye. Hicks?
Aye.
Aye. Hutchings? Aye. James?
No.
No. Kinsky?
Aye.
Aye. Cole?
Aye.
Aye. Cost?
Aye.
Aye. Landon?
Aye.
Aye. McCune?
No.
No. Nethercott?
Aye.
Aye. Pappas?
Aye.
Aye. Perkins?
Perkins, aye.
Perkins, aye. Rothfuss?
Aye.
Aye. Salazar?
No.
No. Schuler?
Aye.
Aye. Scott?
Aye.
Aye. Steinmetz?
Aye.
Aye. Wasserberger?
Aye.
Aye. President Dockstetter?
Aye.
Aye. Closing vote? Closing.
Case changes to no.
Case, aye to no.
Correct. Thank you.
Closing vote. Closing. Vote closed. Joint rule number 2 amendment has a vote of 22 aye, 6 no, 1 excused, 1 absent.
Thank you. Motion to amend has passed. Reports from standing committees.
Mr. President, February 1st, 2021, your committee number 10, Labor, Health, and Social Services, to whom was referred House Bill 3, Certified Addictions Practitioners Certification Amendments, respectfully report same back to the Senate with the recommendation that it do pass. Voting ayes, Senators Baldwin, Bouchard, Furphy, Hutchings, and McCune. Signed, Senator Baldwin, Chairman. Mr. President, your committee number 1, Judiciary, to whom was referred House Bill 34 engrossed, Youthful Offender Program Amendments, respectfully report same back to the Senate with the recommendation that it do pass. Voting aye, Senators Cooper, French, Cole, Cost, and Nethercott. Signed, Tara Nethercott, Chairman. Mr. President, your committee number 1, Judiciary, to whom was referred House Bill 42 engrossed, Chancery Court Vacancy Amendments, respectfully report same back to the Senate with the recommendation that it do pass. Voting aye, Senators Cooper, French, Cole, Cost, and Nethercott. Signed, Tara Nethercott, Chairman. Mr. President, your committee number 2, Appropriations, to whom was referred House Bill 48, Community Juvenile Services Block Grant Program, respectfully report same back to the Senate with the recommendation that it do pass. Voting aye, Senators Guru, Hicks, Kinsky, and Steinmetz. Senator Perkins excused. Signed, Dave Kinsky, Acting Chairman.
Thank you. House bills on first reading. House Bill 4, first reading of the bill.
House Bill 4, Mental Health Professionals Practice Act Amendments, passed the House 60 ayes, sponsored by Labor.
House Bill 4 is referred to Committee Number 10, Labor and Health. House Bill 8, first reading of the bill. Excuse me, House Bill 25, first reading of the bill. Excuse me.
House Bill 25, Tribal Vehicle Registration Exemptions Implementation, passed the House on a vote of 44 aye, 16 no, sponsored by Select Tribal Relations.
House Bill 8 is referred to Committee Number 8, Transportation. House Bill 53.
Mr. President, would you repeat that, please?
Point of order, Mr. President.
Please.
Named the wrong bill.
Excuse me? House Bill, okay. House Bill 25 is referred to Committee Number 8, Transportation. House Bill 53, first reading of the bill.
House Bill 53, Invasive Plant Species, sponsored by Agriculture, passed the House on a vote of 58 aye, 2 no.
House Bill 53 is referred to Committee Number 5, Agriculture. House Bill 15, first reading of the bill.
House Bill 15, Department of Transportation Communications Facilities, sponsored by corporations, passed the House on a vote of 60 aye.
House Bill 15 is referred to Committee Number 7, Corporations. House Bill 18, first reading of the bill.
House Bill 18, Military Training Memorials, sponsored by Transportation, passed the House on a vote of 46 aye, 14 no.
House Bill 18 is referred to Committee Number 8, Transportation. House Bill 30, first reading of the bill.
House Bill 30, Public Utility Assessment, sponsored by Revenue, passed the House on a vote of 39 aye, 21 no.
House Bill 30 is referred to Committee Number 3, Revenue. House Bill 35, first reading of the bill.
Mr. President, we did not receive 35.
On that, thank you. Bills on third reading.
Mr.
And final.
President,
Please go ahead.
I did have a couple of more.
I don't have them on my list. Would you give them to me?
They are House Bills 4, 15, and 25.
And we read House Bill 4 and 15 and 20.
Oh, I'm sorry.
Yeah, those have been read.
Okay, no problem. Thank you.
Okay, thank you. A moment. It's hard working in separate rooms. Let's proceed. Bills on third and final passage. Senate File 21, third reading of the Senate file.
Senate File 21, Judicial Review of Agency Actions, Permissible Venues, sponsored by Judiciary.
There are no amendments.
Mr. President,
Discussion on the bill. Chairman Scott. Go ahead.
Mr. President,
I ask this bill be pulled off the consent list. Mr. President, my concern with this bill, and I intend to vote against it unless I'm persuaded otherwise by the debate, is that I'm afraid it leaves us open to the evil practice of venue shopping in cases. And we've seen a good deal of that at the federal level with some obvious injustice being done. I think the examples come to mind are how difficult it's been to get the delisting of the grizzly bear done, even when they have saturated their habitat as they have in Wyoming. And I don't want us at state level getting into that. As I read it, what this bill does is it gives another venue possibly for these actions. Without the bill, the existing law is you can have venue where the administrative agency involved is located, which often would be Cheyenne. You can have venue if real property is involved, where that is. The court can have jurisdiction where one of the parties to the case lives. This adds wherever the accident involved was. And Mr. President, that seems to me, for a number of cases, that'll be one of the three that's already a place you can bring the action, particularly where somebody lives or has their principal place of business. But this is adding another thing, and with our mobile society, this could be a location that's entirely across the state for the various parties. And I think it adds the possibility for mischief in the venue shopping. And I don't think it really adds anything to the ability of the parties of these cases to get justice. And I'd like to hear a little more discussion as to why this is being done.
Senator Scott, further discussion on Senate File 21. Senator Chairman Nethercott.
Thank you, Mr. President. I guess this is on the motion to remove this bill from the consent list. Is that correct?
Correct. And well, go ahead, Senator Scott.
Mr. Chairman, my understanding was that this is on the third reading of the bill, and the question
Correct.
is, we passed the bill or not.
Correct.
It was removed from the consent list on
Removed
Friday.
earlier. Go ahead, Chairman Nethercott.
Thank you, Mr. President. So I just emailed the entire Senate the information that the Joint Judiciary Committee considered in the interim. As a reminder of how this bill came to be, it originated from a case called in the matter of the workers' compensation claim for McAllister versus the State of Wyoming Department of Workforce Services Compensation Division. And so as part of the Judiciary Committee's work to review the Supreme Court opinions, this particular case came up. The LSO provided a memo to the committee that's also just been provided by you that summarizes what happened in that case. And in that case, I'm just going to kind of read to you from the memo in order to provide you the most specific information. In the McAllister case, an employee injured his spine while working for a grinding company in Campbell County. The employee lived in a home in rural Albany County. And this has been a long history that the Wyoming Supreme Court has dealt with from 2000. And so this actually corrects a mischief in our law that's gone on for decades. And so the McAllister case references the 2000 case. That's similar to the 2000 case. The employee's physicians requested that the Workers' Compensation Division purchase some non-typical items to help him manage his condition at his home. The division refused, and the employee requested a contested case hearing that was held in person in Laramie County. In the administrative proceeding, the division's pleadings were captioned the State of Wyoming, Campbell County. The Office of Administrative Hearings, which held the contested case hearing, upheld the division's denial. After this, the employee filed a petition for review in the district court in Campbell County, asserting that the district court had jurisdiction under, among other statutes, Wyoming Statute 163114A, and that the venue was proper because the employee was employed in Campbell County at the time of his injury. He was employed in Campbell County at the time of his injury. So his employer is actually in Campbell County. The division moved to dismiss for lack of jurisdiction, asserting that he should not have filed in the Campbell County District Court. The district court denied the motion to dismiss. So the district court judge denied the motion to dismiss and affirmed the denial of benefits on the merits as a result of an appeal being filed in the Campbell County District Court. Now, I assure you that venue shopping within the state of Wyoming is far different than venue shopping across the country's federal circuits. But the employee appealed, and the division again asserted that the district court in Campbell County lacked subject matter jurisdiction over the employee's appeal. A majority of the Supreme Court agreed with the division and dismissed the appeal. The court read the language in Wyoming Statute 163114A to conclude that the legislature intended that the courts listed in 163114A to be a jurisdictional requirement, one where the right of judicial review to agencies' actions was limited to certain enumerated districts. The court also overruled the 2000 case, which had been the law up to that point in time. So the litigant who filed in Campbell County followed a 2000 case where the Supreme Court had held that they could file in that area, which would be consistent with other rules of civil procedure associated with the filings of actions. So I could sue in Campbell County, but I couldn't have an appellate review in Campbell County, which seems a little silly. But the court also overruled the 2000 case to that extent that it was inconsistent with the decision. The court noted that the 2000 case did not consider the language at all, and that the court was not at liberty in that case to wholly ignore statutes or to rewrite them to accomplish judicial efficiency, because of course that appeal could be refiled in a different court. The court also concluded that the division's use of Campbell County did not somehow vest jurisdiction in Campbell County's district court, noting that the employee cited nothing to show that any agency action was taken in Campbell County, which was connected to the case only because it was where the injury occurred. Ultimately, the court concluded that the statutory provision cannot be read as stating that an aggrieved party is entitled to judicial review in the county where he was employed or the county where he was injured. One justice dissented. The justice noted that the legislature had taken no action in light of the court's 2000 case. So for the last 20 years, that was the law on the books as a result of a Wyoming Supreme Court opinion of 2000. And cited cases holding that when this court interprets a statute and the Wyoming legislature takes no action to change it, the court will deem the legislature to have acquiesced in our interpretation. So for 20 years, we did in fact acquiesce. The justice noted that the legislature hadn't acted in 19 years at that time after the 2000 case, suggesting that despite the lack of analysis in the 2000 case, the legislature's inaction sanctifies the court's earlier holding. The justice also noted that the court doesn't defer to a decision by a district court on a petition for review. Instead, the Supreme Court reviews an administrative action as if it comes directly to that court, obviating any concerns for venue shopping when it comes to petitions for appellate review. Because when the Supreme Court gets it, which is the appellate's right, the court reviews that just as like it's hearing it for the very first time. Ultimately, this justice would have concluded that without a clear indication from the legislature that Wyoming Statute 163114A isn't a statute that limits jurisdiction, but one that is a rule of venue. And so you can see there, we're not trying to create further harm, but really trying to clarify the the legislative intent as a result of two different interpretations from the Wyoming Supreme Court concerning an issue of where a case could be filed, and particularly simply a case of appellate review. It's not anything particularly profound, but does allow for a court to review a decision on the merits instead of kind of creating a tricky outcome for litigants for where they might file an appeal. So again, it's not the trial court. The trial court, which is where the venue shopping you might be more concerned about. This is where the judge will just be receiving briefs by lawyers to make a decision about. It's not actually the trial court. The Office of Administrative Hearings, uniquely enough, conducts these trials all across the state in conference rooms and courtrooms and different locations based really on the convenience of the parties, regardless of location. It's the Office of Administrative Hearings who makes that determination at the trial court level, determining facts. Happy to stand for any questions.
Further discussion on Senate File 21. Members of the Senate, those listening, we are on Senate File 21, Judicial Review of Agency Actions, Permissible Venues. We are in the discussion right now. Further discussion from members of the Senate. Further discussion. Okay. Are you ready for the question? Question being called. Senate File 21, having been read 3 separate times, the question is, shall the bill pass? Chief Clerk will call the roll.
Anderson, absent. Baldwin?
Aye.
Aye. Whiteman, excused. Boner?
Aye.
Aye. Bouchard?
Aye.
Aye. Case?
Aye.
Aye. Cooper?
Aye.
Aye. Driscoll?
Aye.
Aye. Ellis?
Aye.
Aye. French?
Aye.
Aye. Furphy?
Aye.
Aye. Guru?
Aye.
Aye. Hicks?
Aye.
Aye. Hutchings? Aye. Aye. James?
Aye.
Aye. Kinsky?
Aye.
Aye. Cole?
Aye.
Aye. Cost?
Aye.
Aye. Landon?
Aye.
Aye. McCune?
Aye.
Aye. Nethercott?
Aye.
Aye. Pappas?
Aye.
Aye. Perkins?
Aye.
Aye. Rothfuss?
Aye.
Aye. Salazar?
Aye.
Aye. Schuler?
Aye.
Aye. Scott?
Aye.
Aye. Steinmetz?
Aye.
Aye. Wasserberger?
Aye.
Aye. President Dogstetter?
Aye.
Aye. Closing vote. Closing. Vote closed. Senate File 21, 28 aye, 1 excused, 1 absent.
Senate File 21, having received the affirmative vote of the majority of the members elected to the Senate, Senate File 21 has passed the Senate. Senate File 50, third reading of the Senate file.
Senate File 50, COVID-19 Business Relief Programs Agriculture, sponsored by Agriculture.
There is an amendment. The reading clerk read the amendment.
Senate File 50, third reading amendment number 1, corrected copy, page 1, line 3.
Discussion on Senate File 50 and the amendment.
Thank you, Mr. Chairman. I move third reading number 1 to Senate File 50. So what this amendment will do is will ensure that those who did not get money out of the first tranche of COVID funding will have the opportunity to get it this time, because those who received it the first time will be those who received the funds the first time or were denied will not be able to get it. And so that will make sure that the new applicants will have the opportunity. So that's basically what this amendment does.
Amendment has been moved. Is there further discussion on the amendment? Third reading amendment number 1 to Senate File 50.
Mr. President.
Mr. Chairman Perkins.
Thank you. A question for the sponsor. As I read the requirement that third reading amendment number 1 to Senate File 50 provides, it is that no agricultural business that has already applied for relief through the Wyoming Business Interruption Program shall be eligible to receive funds. And so it's not, if you've applied, I noted that the sponsor indicated that you had to apply, and two, that you had to have received. In this case, it's already applied. So actually, I think that if you applied and were denied, I think the effect of the amendment would still be that you cannot apply, reapply, because you've already applied. The second criteria that was represented isn't, I don't see it in the new language. And so I don't know. Anyway, I just bring that to the sponsor's attention, that it may not be quite what the sponsor thought it was.
Thank you. Further discussion, Senator, it was Senator Wasberger and then Senator Case in that order.
Well, thank you, Mr. Chairman. On and against the amendment. Essentially, I think our other COVID funds have allowed various different businesses to receive funding or relief or grants twice if necessary. If the agricultural business can prove a loss, they proved it in their first application and awarded it, and then they approve it they apply and show a loss and are approved, they should still receive the COVID CARES Act money. So on and against the amendment. Thank you, Mr. President.
Thank you. Senator Case, thank you for your patience. I'd seen Senator Wasberger's hand flash earlier, so let's go now to Chairman Case.
Thank you very much, Mr. President. No worries whatsoever. Mr. President, as I recall the discussion from this bill when it was introduced and discussed, it related to the fact that our friends in agriculture weren't necessarily able to show a monetary loss in the sense that there were no sales in their business, as I recall. So even though the value, say, of cattle fell tremendously, they weren't able to bring that forward and receive funding before. And that this bill is an attempt to kind of correct that and say, no, you really did have a loss, and realize that even though you kind of failed the strict test that was imposed before, which had to do with revenues, whether your revenues went down. So I'm thinking it could be that following that logic, that's the whole purpose of the bill, as I understand it. Please correct me if I'm wrong, that if you couldn't show it because you didn't actually sell anything at the time, but indeed you did have a loss, then this amendment would seem to defeat the whole purpose of the bill. So I'd like some help with that. Thank you very much, Mr. President.
Thank you. Before we go back to Senator James, further questions and comments? Senator Boner.
Thank you, Mr. Chairman. Not going to repeat the concerns that have already been expressed by my colleagues. Just want to commend the sponsor for the intent of the amendment. I don't think it quite gets us there. As Senator from Casper pointed out, this would disqualify anybody who's merely applied for any funds, not necessarily those who received funds. And I think that we'll have a more robust discussion potentially in March as to how to deal with not just ag businesses, but all businesses who maybe have already applied and received some funds. Maybe they weren't sufficient in some instances, maybe they were. But I think that's a broader discussion that we can have in March when we take into account the totality of the program still available. So on against the amendment, but I think that the intent is good.
Senator Scott, and then Senator Cooper.
Mr. President, and understand that I'm in a group that has a conflict on this one. But I wanted to answer the question from the senator from Fremont County. I think it's a little more complicated. There were two factors involved as I understood it. One was that the sales that were involved may well have occurred late in the year, so they would have time getting the application done and completed, and that some operations that may have even occurred in January. There was a second factor, and that is the prices. And I'll speak to cattle because that's what we've got and what I'm familiar with. The prices were for calves and yearlings were off. The fat cattle prices, which are for most Wyoming operations, not what's involved, were off quite a bit for a while because the packing plants had trouble processing animals because their workforce got the COVID, and a number of them had to close for a period. So that, and there's some other factors there where the COVID depressed the market, but a broad market like livestock or other agricultural commodities, you know, droughts play into it. Overall demand, which was probably affected by COVID, plays into it. There's a number of factors, and it's hard to figure. So, as I understand this bill, you don't have to show a loss in your operation, which will be affected by many other things, interest rates, droughts, a whole bunch of other stuff like that. But simply that you took some loss because COVID drove the prices down. I hope that's an adequate explanation of it, but it's more complicated than just the timing factor, Mr. President. And again, I would emphasize that's from somebody in the business who does have an interest in this bill.
Thank you. Senator Cooper on the amendment.
Mr. Chairman, thank you very much for recognizing me. I'd like to roughly reiterate what the senator from Page Creek just talked about, is the timing of it. But there's some other factors involved too. A lot of the cattle that were involved were actually sold in December and January. Cattle business, they get basically one paycheck a year, and you don't know what your profit is or your loss is until those cattle are actually sold. Also, the issue of our barley farmers up in the area. Many of those farmers got their contracts cut in half by the beer companies, if you will. They had a contract in place. The contractors came back and said, no, we're not going to take all that barley. We're going to cut that in half. And then they raised the numbers, they lowered the numbers. So at the time of when this filing had to be, our barley farmers had absolutely no idea what they were even going to be able to sell as far as malt barley, or what would have to be degraded to feed barley. So there's a lot of other factors, just as the senator from Bench Creek talked about, that precluded these ag producers from participating in these programs. And I think that the context of this bill is to give them the opportunity to finally participate. And with that, I think the bill as stated was the proper bill. Thank you.
Thank you, Senator. On the amendment, Senator Hicks, Vice President Hicks.
Yeah, Mr. President, I'm not so sure that the sponsor of the amendment didn't accurately articulate what the amendment does. And so you have to go down to line 12. So I would agree that if somebody already applied and they did not receive money, that's because the criteria made them ineligible. But if you go down to line 12, it says, unless the eligibility criteria is materially different than that at the time of the initial application. So even somebody that would have applied under the old criteria that was deemed uneligible could now turn around, assuming that the criteria would change, which I think that's part of the direction in the actual bill. Those applicants could then turn around and reapply for those monies. So I do think it starts, so if you put this in context of the entire bill, my recollection is, not having it right in front of me, is it starts to specify different criteria than what the original program had. And so when you read that in context with the amendment, I do think it allows those people that applied and were denied because of the criteria, that if the bill goes into force and effect and directs a new criteria, those applicants would be able to reapply for those interruption funds. So the way I read it, I think it meets the intent of what the sponsor was trying to do when you put it in context of the overall bill. But that may be just my reading of it, Mr. President.
Thank you. We go now on the amendment to Senator Schuler and then to Chairman Perkins.
Thank you, Mr. President. Yeah, just to kind of tag along with some of the comments. I think I understand the bringer of the amendment, and I definitely see that there's some issues there that I think maybe just a couple of wordsmith types of things that maybe would have helped it. I think if there had been something in there about prioritized, if you had received funds, applied and received funds, and then maybe you would be, dropped to the bottom of the list or something previously. I think we did that with one of the other Wyoming Business Council tranches of money. I don't remember if it was the relief fund or the interruption fund or which one it was, but I think we talked about the fact that if they had received SBA loans or PPP loans or something like this, that maybe they wouldn't be prioritized quite as high. So I understand what the amendment is trying to do, and I just think maybe if it was worded a little bit differently, I could get on board with it, but maybe just prioritize a little bit differently, but on and against the amendment. Thank you.
Thank you, Senator. Senator Perkins.
Thank you, Mr. President, for my second time. And I'm always very hesitant to argue with our vice president over these things. But even if you take the lines 12, begin on line 12, I understand what the vice president is saying, but the flip side of that is that the other representation was if you had already received some kind of benefit out of this program that you would apply. But taking the vice president's analysis, again, if the criteria are different, it wouldn't preclude someone who'd already received it. Now, I don't think they can be compensated for the same loss that they would have already received, but they could still receive compensation for additional loss or a different loss than they had originally received. But anyway, that if it's there, I mean, that gate is going to swing both ways, I guess is the point. And I'm concerned, at this date, if there was time to lay this back a day, we could fix this. But the problem is, I don't think there's time to lay it back a day and have this bill make it through this session. And so I just think that in this case, I think it's a great idea. I don't have any problem. I think it's a commendable idea. I think the sponsor was right for us to put some sideboards on it if that's what we wanted to do. But I think I don't think it quite hits the mark, and that's easy to fix. It can go to the other house and they can fix this. They can make the wordsmithing, whatever needs to be done. We do need to move the bill along. I'm just afraid this amendment doesn't accomplish what the bringer intended it to accomplish. Thank you, Mr. President.
Thank you, Senator Rothfuss.
Thank you, Mr. President. And I agree that the intent is sound, but that it doesn't quite get to the objective. And my suggestion would be for the chairman of the Ag Committee to communicate with the chairman down the hall, if we actually had halls at this point, and try and express this idea of ensuring that prior funding should be taken into consideration as the program moves forward. And I'm sure the good chairman can take care of that and accomplish the objective of the senator. But I agree with the interpretations that have been presented that this doesn't quite hit the arrow in the bullseye. So we probably need to defeat this amendment and then get it corrected down the hall.
Thank you. Further discussion on the amendment? Further discussion on the amendment? Are you ready for the question? Question is, shall third reading amendment number 1 to Senate File 50 pass? All those in favor say aye with your hand. Hold them up for the chief clerk.
One.
Two. Madam Chief Clerk, we have 2. Those opposed, 2. Thank you.
$21.
Thank you. The amendment has failed. Now we're back on the bill. Senate File 50, COVID-19 Business Relief Programs, Agriculture. Further discussion on the bill? Are you ready for the question? Question being called. Senate File 50, having been read 3 separate times, the question is, shall the bill pass? The chief clerk will call the roll.
Anderson, absent. Baldwin.
Aye.
Aye. Beitman, excused. Boner.
Aye.
Aye. Bouchard.
Aye.
Aye. Case. Case.
Aye.
Aye. Cooper, conflict.
Conflict.
Correct.
Driscoll, conflict.
Yes. Conflict.
Ellis.
Aye.
Aye. French.
Aye.
Aye. Furphy.
Aye.
Aye. Guru.
Aye.
Aye. Hicks.
Aye.
Aye. Hutchings.
Aye.
Aye. James.
Aye.
Aye. Kinsky.
Aye.
Aye. Cole.
Aye.
Aye. Cost.
Aye.
Aye. Landon.
Aye.
Aye. McCune.
Aye.
Aye. Nethercott.
Aye.
Aye. Pappas.
Aye.
Aye. Perkins.
Aye.
Aye. Rothfuss.
Aye.
Aye. Salazar.
Aye.
Aye. Schuler.
Aye.
Aye. Scott.
Conflict.
Thank you. Steinmetz.
Aye.
Aye. Wasserberger.
Aye.
Aye. President Dockstetter.
Aye.
Aye. Closing vote. Closing vote closed. Senate File 50, 25 aye, 1 excused, 1 absent, 3 conflict.
Senate File 50, having received the affirmative vote of the majority of the members elected to the Senate, Senate File 50 has passed the Senate. Senate File 56, third reading of the Senate file.
Senate File 56, Wyoming Gaming Commission Modifications and Corrections, sponsored by Travel.
Senate File 56, any discussion on the file? Senate File 50, Senator Rothfuss.
Thank you, Mr. President. Mr. President, I do have a question for the proponents, and it comes not from a concern of any specific issue, which I think this bill is necessary. I think it does good things, and I think there's been a lot of work that has gone into it, but it's actually that latter concern that I wanted to raise, which is, we had a full substitute bill on committee of the whole, and then we had some pretty extensive modification to that substitute bill through amendment on the floor. And my question is, would it make more sense for us to slow this one down, make sure that we've got everything right, get feedback and more opportunity for stakeholder engagement based on the changes that were put forward? Or should we be confident that this is ready to go? And, I don't know the answer. This is not one of the areas where I've really spent a lot of time focusing, so I'd rely on the thoughts of those that really have spent time on it. I do know that we need to get something done this session because of the sunset, and so I support the concept with no concern. But I'm left just a little bit uncomfortable with the idea that we'd be moving forward a bill with such substantial changes over a virtual session in the expedited portion of the session. And so I ask proponents if they are comfortable that this has seen enough scrutiny from stakeholders and that everyone should be comfortable with it, or if we should look for opportunities to slow it down a little bit, allow for more discussion. And I just ask our good chairwoman and the majority floor leader and others that have been more involved in this debate than I have for their thoughts on that concern.
Third reading discussion on Senate File 56, Wyoming Gaming Commission modifications and corrections. Further discussion? Senator Driscoll, Mr. Majority Floor Leader.
Mr. Chairman, I'll probably be followed up by the TRW chairman, I believe, but I am comfortable. We were prepared to lay this bill back over the weekend with extensive visiting with large groups of the stakeholders across. They felt that they'd like to see it go forward. Also had a visit with the other body, and they're going to give it a great hearing going through as well. I'm not sure I legally can say that, but I feel very comfortable leaving here that at the end, we're going to end up with a very good product that's good. And I very much appreciate the effort that's gone into it to get it into great form. Thank you.
Further discussion on Senate File 56? Discussion on Senate File 56. Further discussion. Senator Garreau.
Thank you, Mr. Chairman. I too shared some of the concerns that my good friend from Gem City of the Plains was expressing, and I talked to some of the stakeholders and actually spent some time with our chair from TRW, and we discussed it and walked through it. And I think she did great work. Fast work, but great work. And, you know, at the end of the day, this whole deal with gaming in our state is a work in progress. And I agree with the majority floor leader when he says that the other body down the hall is going to give the good going over. And I think that this will not be the end of this even after that process, that we're going to continue to work and continue to refine this. It's a good step. It did have a few moving parts in it, which necessitated some changes. But I'm actually glad they got made and in support of the bill. Thank you, Mr. Chairman.
Senator, we are discussing Senate File 56. Senator Schuler.
Thank you, Mr. President. I also had some stakeholders reach out to me as well, probably just because I'm on the TRW. But also, I think I felt the urge to go and visit with some of the operators here in my community, just to actually show them the bill and see if they had any trepidation over anything that we had changed or added. Didn't have any issues with anybody at all. In fact, the big thing is they feel comfortable with it. They feel like it needs to happen. We need to move it forward. And I went over and over again this weekend, just seeing if there was anything at all that I felt uncomfortable with. And I really don't see anything. So on and for the bill. Thank you.
For the discussion, Senator Landon.
Well, Mr. President, thank you. You can tell what the TRW committee was up to this weekend. I just want to echo what my two good friends have just said. And boy, I understand where the senator from Albany County is coming from. We don't generally see that amount of work and that kind of a substitute bill process very often. And what sort of compounded the consternation for me was just simply that we were in a really strange format. You know, we're in the Hollywood Square format, so that makes it a little tougher to walk across the aisleway and visit with one another. But I went through the bill as well, had a good conversation with our chairman. I think that the thing that the senator from Teton County pointed out so well is that we're in a world, we just stood up a gaming commission. And I think that all of us understood when we took that vote that we were going to step into a whole different league. And I think it's incumbent upon us to, as I said the other day, keep this on our interim list and keep working it. We've got a whole new ball game out across there. I don't know a lot about these skill games, but I know this: we've got to have some framework in place so that our commission knows what we expect of them. And the chairman did a good job, I think, of getting that language to where it is today. So I support the bill. At the same time, understand where the senator from Albany County is coming from. But I think the bill is good and ready to go. Thank you.
Thank you, Senator. Senator Scott and then Senator James in that order.
Mr. President, I've got a question, and I think part of my problem is just the virtual session. I don't have as good an information as I would. My understanding is that the amendments we've put on so far have not significantly affected the key restrictions on operations that are found on page 5, starting at line 10 and going over onto the top of page 6. The substance of those is intact with all these amendments, because I think those are the absolute key to keeping this on the straight and narrow and worth voting for.
Thank you, Senator. Senator James.
Thank you, Mr. President. I hate this bill. It's basically growth of government and then extorting private sector for even staying in business. But they need this bill and they want this bill. And that's the only way that they can stay in business. And if government is going to be able to, if the private sector is going to be able to stay here and government is going to be able to continue being funded, then unfortunately at this time we need this, or they need this. So I regrettably encourage you to support it. So yeah, thank you.
Thank you, Senator. Further discussion on Senate File 56? Further discussion? Oh, Senator Rothfuss.
Thanks, Mr. President. For my second time, I'll just say I appreciate all of the feedback from the members of the TRW committee, the experts that have been working this, and it sounds like they've done the necessary due diligence. They've contacted the stakeholders. They're all comfortable with it. So I'm gonna trust the good work of that committee and support it. And I really appreciate the feedback and the outreach on that. Thanks, everyone.
Thank you, Senator. Further discussion on Senate File 56? Senator Ellis, Chairman Ellis.
Thank you, Mr. President. Just want to echo what everyone said. A lot of work has been going on to this, and it's a fast-moving session. We're doing it virtually, so I think that adds to the challenge. But I just want to clarify with the substitute bill, what necessitated that was really the fact that we had laws written in our session laws that needed to be codified. And so as you look at the length of the bill, a lot of that had been approved by this body, about a year ago. It was just moving it over. And then the additional changes that were added really kind of came to light last minute to me. I was unaware of several lawsuits that had been filed, mainly because this body hadn't made it very clear in its statute about what standards of review would apply when the Gaming Commission decides to take any action on these applications. If they're going to deny them, approve them, revoke them, are these folks entitled to have a hearing? And so really, this bill, in my view, isn't necessary just to provide the removal of the sunset. It provides regulatory certainty, and it also makes it clear what we intended. So if the Gaming Commission wants to deny these applicants, we know that what protections and due process are afforded. And so, senators, to me, this is a very important bill. And I know that, to the good senator from Sweetwater County, there are industries that are regulated. This happens to be one of them. And anyone that wants to do business in Wyoming, they want to play by the rules. They want some certainty, and that's what this bill provides. So I would urge everyone to support its adoption. And it is a work in progress, so I think we'll keep working on it. I'm sure the House will have some suggestions that we might like. Excuse me, I'm sorry, Mr. President, my apologies. The other chamber, I'm sure there's more process and more discussion on this bill, but I'd urge your aye vote today.
Thank you, Madam Chair. The chairman spoke. Any further discussion? Question on Senate File 56. Having been read 3 separate times, the question is, shall the bill pass? The Chief Clerk will call the roll.
Senate File 56 roll call. Anderson, absent. Baldwin.
Aye.
Aye. Beitman excused. Boner.
Aye.
Aye. Bouchard.
Aye.
Aye. Case.
No.
No. Cooper.
Aye.
Aye. Driscoll. Aye. Ellis.
Aye.
Aye. French.
Aye.
Aye. Furphy.
Aye.
Aye. Guru.
Aye.
Aye. Hicks.
Aye.
Aye. Hutchings?
No.
No. James?
Aye.
Aye. Kinsky?
No.
No. Cole?
Aye.
Aye. Cost?
Aye.
Aye. Landon?
Aye.
Aye. McCune?
Aye.
Aye. Nethercott, conflict?
Conflict.
Thank you. Conflict, Pappas?
Aye.
Aye. Perkins?
No.
No. Rothfuss?
Aye.
Aye. Salazar?
Aye.
Aye. Schuler?
Aye.
Aye. Scott?
Aye.
Aye. Steinmetz?
No.
No. Wasserberger?
Aye.
Aye. President Dockstader?
Aye.
Aye. Closing vote? Closing. Vote closed. Senate File 56, 22 aye, 5 no, 1 excused, 1 absent, 1 conflict.
Senate File 56, having received the affirmative vote of the majority of the members elected to the Senate, Senate File 56 has passed the Senate. Let's go to standing committee reports. We've had some come through. Madam Chief Clerk.
Thank you, Mr. President. February 1st, 2021. Mr. President, your committee number 9, Minerals, Business and Economic Development, to whom was referred House Bill 6, Trust Company Amendments, respectfully reports the same back to the Senate with the recommendation that it do pass. Signing aye, or voting aye, Senators Cooper, Rothfuss, and Wasserberger. Senator Anderson absent, Senator Beitman excused. Signed, Jeff Wasserberger, Acting Chairman. Mr. President, your committee number 9, Minerals, Business and Economic Development, to whom is referred House Bill 8 engrossed, Consumer Credit Amendments, respectfully reports same back to the Senate with a recommendation that it do pass with the following amendment. Voting aye, Senators Cooper, Rothfuss, and Wasserberger. Absent, Senator Anderson. Excused, Senator Beitman. Signed, Jeff Wasserberger, Acting Chairman. Mr. President, your committee number 9, Minerals, Business and Economic Development, to whom was referred House Bill 9 engrossed, Short Time Compensation Program, respectfully reports back to the Senate with a recommendation that it do pass. Voting aye, Senator Rothfuss and Wasserberger. Absent, Senator Anderson. Excused, Senator Beitman. Signed, Jeff Wasserberger, Acting Chairman.
Thank you. So at this point, consideration of bills on general file. Mr. Majority.
President?
Oh, please. Oh, Senator Hicks, sorry.
Could I have privilege of the floor, Mr. President?
Please, Mr. Vice President.
Yeah, Mr. President, members of the body, if you haven't already responded, you have an email from LSO requesting information if the vaccines become available, whether you would be interested in getting vaccinated. They need to have an answer by 3 o'clock today. So if you have not answered that email, would you please do so? We're trying to get a list of individuals if the vaccine that would become available, how many people would be interested in taking that prior to the March 1. So we're just trying to get an idea of what that number might be if the vaccines were available. So please respond to that email so LSO will have an idea of how many legislators or how many senators that would be. Thank you, Mr. President.
Thank you, Mr. Vice President. 45 minutes. Just go ahead and get it taken care of. Respond one way or another. Consideration of bills on general file. Mr. Majority Floor Leader, we are at that order of business. Consideration of bills on general file.
Mr. President, I move that the Senate resolve itself into the committee of the whole.
You have heard the motion. All those in favor say aye.
Aye. Aye.
Those opposed say no. Motion carried. Senator Kinsky, would you please preside over the Senate?
Thank you, Mr. Chairman. The Committee of the Whole will please come to order. The first bill for our consideration is House Bill 34, Youthful Offender Program Amendments. The reading clerk will read the House bill.
House Bill 34, Youthful Offender Program Amendments, an act relating to the Youthful Offender Program, sponsored by Judiciary. It was referred to Committee Number 1, who returned a due pass recommendation. Voting aye, Senators Cooper, French, Cole, Cost, and Nethercott. Signed, Tara Nethercott, Chairman.
You've heard the reading of the bill. What is your pleasure? Senator Nethercott.
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the due pass recommendation of House Bill 34, Youthful Offender Program Amendments. And to explain this good little bill, I'll call on the good Senator Kolb.
Thank you.
Kolb.
Good senators, before you is a bill that updates the old boot camp program. In summary, the name changed the program to Youthful Offender Program, adding peer specialists with certified training, which are long-term inmates to provide positive guided peer support. Age requirements change, adding has not attained the age, shifting from 25 years of age to 30 years of age, adding females to the program. And I shall stand for any questions. Thank you.
Thank you. Questions for the presenter? Questions? Looking, trying to make sure I've got everybody within sight. I don't see any questions.
Mr. Chairman, I am shocked. My Judiciary Committee has been concerned about the level of questions that they will get on these bills, seeing what's been presented to me so far. I am just shocked there are no questions on this good little bill.
Madam Chairwoman, I think it just reflects the level of preparation that the presenter of the bill brought to the floor, that they were so thorough. Oops, Mr. Vice President.
Mr. Chairman, to my colleague and the chairman of the Judiciary Committee, ask and you shall receive questions. And so just walk us through. I'm trying to, in my mind, remember what is this youthful offender program? Is this something that was conducted by, I just want to make sure this is not the Challenge Youth Academy that the Guard runs. And can you provide me an explanation of the difference between this program and how it's different from that program?
Thank you, Mr. Chairman. Senator Hicks. It is not the same program. This is merely a revamping of the old boot camp program under the same statute with some changes and modifications, I think, clarified for current day realities. And so, no, my understanding is there is no similarities, the good senator. And thank you for my chance to comment. I hope that answers the question.
Thank you.
Mr. Chairman?
Yes, please, Mr. Vice President.
So is this run at the medium security, the Honor Farm, the maximum security prison in Rollins? Where is this program implemented at? I see it's expanded to the women's prison, but where is it currently operated out? And what's the, I guess, just a little bit about the eligibility criteria. Who's eligible for the program?
Mr. Senator, please. Senator Cole.
Thank you. I'll read this. Peer specialists, these are folks that are the ones working with the inmates. Means long-term inmates who have completed certified training and been selected and assigned by the department to provide positive guided peer support to the offenders involved in the program under the direction of program staff, provided that peer specialists shall not have direct supervision over inmates. Now, to more directly answer your question, I believe I run through here, it is I believe they have time off upon successful completion. They do get time off their sentence for successful completion of this program. It'll take me a while to find this here. Thank you for your question, the good senator from the Bags area.
Point of order.
Mr. Minority Floor Leader.
Thank you. And my apologies if it just turns out, which is my hope, that I'm completely wrong, but do we have a posting of general file and the order in which committee of whole is going to take place, and I missed it? Obviously not on point, but I've got nothing. So I'm hoping I've just missed it.
I can't answer that question. I'd turn to the majority floor leader or to the clerk.
So I've got a handwritten list. I'm going to read it to everybody, so get your pens handy. First bill, House Bill 34. Next bill, House Bill 42. Next bill, House Bill 3. Next bill, House Bill 6. Next bill, House Bill 8. Next bill, House Bill 9. Last bill for this session, House Bill 48. We'll try to update you better, which has been kind of on the go coming from the House, but that will get us through this session now.
Mr. Floor Leader, just for the benefit of those listening too, if you'd repeat the list after this point of order, thank you.
Point of order, and thank you. And I think the repeat's going to be positive, but I'd actually ask for a brief moment of preparation, because honestly, part of the reason why I know that I have no questions on this one is I didn't know we were going into general file. I didn't know what the bills were going to be, and I certainly didn't get them on my screen. So I don't know if there's amendments. I have no ability to engage in debate at this point. 15 minutes would be great.
Your point of order is well taken. If I'd ask the majority floor leader, please repeat that order, because I've got them not in that order. It would be helpful to me to at least get the right order.
Members of the Senate, let's do this. Let's just take a brief pause, a recess, stand at ease until the sound of the gavel, and we'll get that submitted out. All right? Let's do that.
Mr. President.
Please.
I'd ask, I've been trying to flip through, check for amendments as well. If there's anything that has amendments, perhaps they can put an asterisk or a star by it to double check. We'll stand at recess for 15 minutes.
Okay, let's start having everybody work back into their seats. Okay, we're back. We're back
We'll
live.
come to
then.
order. It'll come to order. Committee of the Whole. How we doing, Mr. President? Do we have an order of the day?
We're good. You call on the floor leader and he's going to go over it for you. Thank you, Mr. Chairman.
Mr. Majority Floor Leader.
Thank you, Mr. Esteemed Chairman. Next bill up will be House Bill 42, Chancery Court Vacancy Amendments. Next bill will be House Bill 3, Certified Addictions Practitioners Certification Amendments. Next bill will be House Bill 6, Trust Company Amendments, followed by House Bill 8, Consumer Credit Amendments, followed by House Bill 9, Short Time Compensation Program, followed by House Bill 48, Community Juvenile Services Block Grant Program. Thank you, Mr. Chairman.
Okay, we're back on House Bill 34, Youthful Offender Program Amendments. And Senator Perkins had his hand up just before we broke. I'm not seeing Senator Perkins. All right, anybody else with any questions? Senator Schuler.
Thank you, Mr. Chairman. Yeah, I actually tried to pop in and hear some of the committee meetings this morning, and I was in and out. Had just a couple of questions on this one. It sounds like a really good program. Just kind of wondered about if you have any data, you may not, on what the success rate has been and in terms of reducing their sentences. And actually, I kind of was really interested in knowing why we moved the age up from 25 to 30 years, what the reasoning was for that. So if you could elaborate on that, I'd appreciate it. Thank you.
Senator Kolb, I'll come back to you right after Senator Perkins had a question before the break.
Thank you, Mr. Chairman. I think that the good senator from Evanston just had took several of the ones I had, but I coming back, you know, what I see is from this is seems to me like it's a fairly substantial, and maybe that's wrong, but it seems like it's a fairly substantial expansion of the program. And so I think, you know, this is the program continues to require separation from the general population. But now, instead of, used to be, if my recollection was, you were sentenced to this by the sentencing judge, that still remains, I think, in effect. However, now it's also a transition program so that people, so that younger or more youthful offenders who were previously serving in the, it would not, may or not have been eligible for the program, which is probably what the purpose of the bill, can now be committed or transferred into the transition program, I'm assuming by the Department of Corrections. And so I'm wondering if there's different, or what the criteria would be for that, for when they come in that direction as opposed by the sentencing judge. Again, I think that it's a great question is, what's the effect on the program from raising it from 25 years of age to 30 years of age? Why are we doing that? How many more people will be in there? And does that create such an age diversity issue between those that are 29 or 30 and those that may be in the program that are maybe were charged as adults and may not even be age 18 yet, but particularly those 18, 19 years of age, now we've got a significant age differential. I'm just wondering about that. Again, where will this be? I think that question was asked, but I didn't hear an answer to it. Where is this going to be? Because it does require separation or segregation from the general population. And so again, on the transition program, how long are we anticipating that individuals will be transferred into this program? I'm assuming the transition is to prepare them to return to civilian life. And I'm wondering, and so I'm just wondering a little bit more about this transition program and how it works from the administrative side when they're not sentenced there initially by the sentencing judge. And is there another state, or where's the program modeled after? Is there a study? Is there another state? Is there another penal system that has implemented this program or similar program? And again, going back to the good Senator from Evanston's question, of what's the results of this, which are usually measured in recidivism or other success metrics from when the individuals come out of this program and are introduced into civilian life. So thank you, Madam Chairman and the other members of the Judiciary Committee. Look forward to hearing these answers.
Senator Cole.
Thank you, Mr. Chairman. I'll go back and address the good senator from Baggs, Wyoming's questions first. It is in fact the program's in Newcastle, and it's currently the Wyoming Honor Conservation Camp and Boot Camp, Wyoming Department of Corrections. Then you had the next question is just what's the I guess the benefit for the person participating in this program. It states that the judge, of course, will make that decision after successful completion of this program. And there's application times within 1 year after the individual began serving a sentence of incarceration at the state penal institution. Moreover, the individuals who are eligible for this program are 18 to 30 years old, and it's technically not attained the age of 30, convicted of a felony with a prison sentence. Both the prosecutor and the defense judge shall have to agree to get a recommendation to the program to participate. The next question, as I recall, was the recidivism rate, which came up this morning, and I believe it was 47%. And the comment from the testimony was it is very similar to the outcome without participating in the program. The age change was brought about because they wanted to encompass more people in this program, just to give a larger benefit to more of the people who potentially would want to participate. I do lack some of the background in this, so the next question I would like our chairman from Judiciary, if she could comment on the more technical parts, which I have not been made aware of yet. But I do thank the body for all your great questions and the help you've given me. Thank you. And
so, Senator Cole, there'll be more great questions to come. Senator Ellis.
Thank you, Mr. Chairman. Just a little more discussion about why the need to insert the compliance with the American Disabilities Act. Was this program engaging in activities that weren't compliant? I'm just curious why there's the double emphasis on it within the bill. Thank you, Mr. Chairman.
Senator Hutchings, and then we'll go to Senator Nethercott.
Thank you, Mr. Chairman. This is a quick one for the chairman. On page 2, lines 20 through 21, it speaks on the fact that they've been convicted of a felony. Are there certain felonies that will be excluded from this program, or is it any and all types of felonies? Thank you.
Senator Nethercott, Madam Chairwoman.
Thank you, Mr. Chairman. Great questions, and I'm really glad that we are hearing these today for a great debate, so there's no surprises on third reading. So who is eligible into this program? They are the same offenders that were eligible previously under the boot camp program. So I think all of you might be familiar with the Wyoming Boot Camp program, which has been on the books since the late 80s. Over the years, it's been a very effective program with a recidivism rate in the high 80s, which means it was successful, particularly for the key target group of which they're honing in on, which is offenders between the ages of 18 and 25 historically. As you see in this bill, the Department of Corrections does think it's in their best interest and those of offenders to increase that age limitation based on their best practices and expertise to the age of 30. The basis for that increase from 25 to 30 is on two reasons primarily. One is an economy of scale. Two, they have done a significant amount of research, and there's continuing development research on brain studies associated when the brain stops developing. And so a great deal of statistical data has gone into the fact that the human brain, particularly the male brain, doesn't stop developing till the ages of 25 and 30 of note. And so they do believe that offenders would benefit from the program as they have historically. The recidivism rate associated with the program, though, has changed over time. And so approximately 6 years ago and prior to its start, it was in the high 80s, or a way to say its success rate. So our prison system in Wyoming is also remarkably good. We have the third lowest recidivism rate in the country, something for us to be very proud of with our Department of Corrections. The boot camp program was also similarly situated. But when you're talking about a young offender, do you want them to go into the prison system, or do you want them to go into an alternative placement situation where they're going to have the same outcome as opposed to being institutionalized or in a traditional prison setting? And I think most of us probably see the wisdom of going into a different type of placement than a traditional prison setting. But as of late, the program has lost its efficacy. And so its success rate, or its recidivism rate, has gone from the high 40s to the low 60s in the last 4 to 6 years. So certainly concerning, but something that the program is committed to correcting, and thus the purpose of the bill associated with that. And so they've modernized the program, again, based on best practices. They're taking it away from the more traditional militant style boot camp and calling it the Youthful Offender Program. So we have new millennials committing crimes, and there is a need to change in order to get the right results associated with rehabilitation and deterrence, quite frankly, and some of those motivations there. They need a different type of system to hopefully get the results that they're seeking. You may recall in the last few years, the Wyoming Department of Corrections was sued by a female defendant who'd been convicted of a felony, who wanted the opportunity to go into the boot camp. And of course, she was precluded from doing that because the boot camp has historically been limited to male offenders. So as a result of that litigation, and in order to be compliant, the program has been expanded into females. And so they are currently in the process of reformatting the program to be available for both genders. That's also the ADA provision is also in there at the request of the Attorney General's office as a result of some of that litigation that the state has experienced associated with those gender inequalities with the Youthful Offender Program. There's also a unique thing in there, and I don't want to distract the body from it, but the good senator who presented the bill mentioned this. There's also the opportunity for long-serving inmates to serve as mentors or peer specialists for some of these youthful offenders, that they go through training. Of course, this doesn't cost the state any money. They're inmates volunteering to kind of serve as mentors and peer specialists. They go through, again, training, like I mentioned, and they'll help these youthful offenders hopefully not come back into the prison system. So the bill does a number of things. One, changes it from a militant style program known as the boot camp to what's called the Youthful Offender Program. 2, it increases the age associated with the program so we can achieve an economy of scale, as well as really target the right offenders we want to get the right recidivism rates we want, which is close to 100, but likely going to be somewhere in the 80s. 3, allows for females, as we talked about, and 4, creates this new program allowing for long-term inmates to serve as these peer specialists. So hopefully that answers your questions associated with some of those. How do you get into the program? No felonies are prohibited. Any offense can get, you can still be eligible for the program, but it does require kind of a collaborative effort between the court, the prosecutor, the defense attorney, the defendant, and the Department of Corrections to determine whether or not this particular offender or defendant is well suited for the program. Historically, it's quite rigorous. It's a 180-day program, was focused on being really regimented and military style. And so they want to make sure that the defendants are successful. And so they want to make sure those applicants are the right offenders for the program. You do have to have a felony conviction with a prison sentence attached.
Thank you, Madam Chair. Senator James, please.
Thank you, Mr. Chairman. So I may have heard this wrong, but back when it was the boot camp, it had a recidivism rate of around 80%, and now it's around 47, if I heard correctly. And now it seems to be a softer, kinder prison system, and we're adapting to the millennials. If I'm not mistaken, isn't prison supposed to not be pleasant? And we're not supposed to make it to where they want to be there. So why are we making it a better place for them and making it to where they want to come back? Shouldn't we be making a miserable place for them? So yeah, it seems that we're trying to adapt to their needs when we should be making it a worse place for them. Yes, I understand that for the ADA and for, for the gender stuff, so girls can go there and stuff like that, but we shouldn't be making it for adaptable for the millennials. Who cares about that? We should be making a miserable place for them. We don't want them to want to come back. So thank you.
Senator Scott. Senator Scott, you're on mute.
Yeah, Mr. Chairman, can you hear me now?
I can.
Okay. Mr. Chairman, in response to that, we've got some guidance from our forefathers in terms of the Constitution, Article 1, Section 15 and Section 16. Article 1, Section 15, Penal Code to be humane. The Penal Code shall be framed on humane principles of reformation and prevention. Article 1, Section 16, Conduct of Jails. No person arrested and confined in jail shall be treated with unnecessary rigor. The erection of safe and comfortable prisons, and inspection in prison, and the humane treatment of prisoners shall be provided for. Mr. Chairman, I think that is very sound guidance from our forefathers. They thought that the point in confining somebody to prison was to reform them. And really, I think our prison system is to be complimented on the skill with which they've been implementing that for the past few years. The recidivism rate that is shown is proof of that. I think we're beyond the stage where we just want to be cruel to people, and where really what we're trying to do is salvage lives and make these prisoners a productive part of society and enable them to live successfully in society without molesting the rest of us. So if this program is going to achieve that, and that's what I hope we'll concentrate on, I think that's the right way to go.
Thank you. Senator Boner.
Thank you, Mr. Chairman. And just to add on from what I remember from the discussion in the interim, and just adding some perspective as somebody like many of us who has been to boot camp in the military, part of the point is to break people down so that, with military boot camp, somebody who's actually going to the armed forces, to ensure that they know how to handle failure. That's a huge part of the boot camp process. And so you can build them up into something that's going to be useful to the military. And just copying and pasting that construct isn't necessarily appropriate, I think, in this situation. That's why I've commend the Department of Corrections for bringing forward this concept. If somebody's in prison, maybe they don't really need to be broken down any much further. That they're already at that point where they have objectively failed at some point in their life. And so, I think that the more nuanced approach is entirely appropriate, given the population that we're dealing with. I don't look at it as being, softer or kinder or for a new generation. I think it's a more critical analysis of what's appropriate from that more disciplined environment and what isn't. And the Department of Corrections coming up with the correct application of the elements of military style training, which are going to help them, while leaving aside the ones that are not helpful or even counterproductive. So I think this bill is a good improvement. It's going to incorporate those best practices and help with that recidivism rate.
Thank you, Senator Perkins, and then Senator French.
Thank you, Mr. Chairman. I do appreciate the additional information from the Chairman of Judiciary. I just have a couple of more questions though that came to mind when she was explaining. So my questions are this. So, and I was wondering if that was going to be up at Newcastle. It's going to be up at the honor camp and use that facility up there. So a couple questions. One is the honor camp at Newcastle have sufficient capacity to absorb what looks to me to be an expansion of the program? I'm assuming the answer to that's going to be yes. But also the other question I have with respect to the peer, what are they called, peer inmates or what that was, are they going to also be assigned to the camp at Newcastle so that they're teaching in person? Or are they going to appear from them? And what problems does that cause if we have these guys who are part of the general population, and other than the segregation, the exception that's created for this program for their participation in it, are they considered general population, or have to be special accommodations made to keep them, except for when they're acting in their capacity as a peer consultant, that they are they not general population when they're there so that they can intermingle? Or just explain how that's going to work. I'm just interested. Thank you, Mr. Chairman.
Senator French.
Just a comment, to us on Senator James's comments. Yeah, prison is a place to pay the consequences for an acts that you should not have done. But having said that, from this morning's discussions, I come away with it as there's a chance for these youthful offenders through. My take was that peer specialists on the woman's side, there's going to be 2, and on the men's side 2, that maybe they can, somebody that's going to be in there for life, for their entire life, they really messed up. Maybe they can get to that young man or that young woman by talking to them, say, God, don't go down. You're already started down that road I've started down. So you have a chance to turn your life around. Is it going to be an easy, hey, you do this, man, you're out on probation and you're back to doing whatever you did before you landed in prison? I think it's an attempt to, through those peer specialists, somebody that's maybe, this is not a good word, somebody that's hardened, to talk to that young person and say, man, think about what you've done. You have a chance. You can still have a chance here. But, this program's not going to be easy, but you have a chance. That just was my observations from this morning.
Thank you, Senator. Senator Nethercott, did you want to pick up on those questions? I'm not seeing other hands.
Thank you, Mr. Chairman. I certainly will. So, yeah, I think it's important to recognize the wisdom of our Department of Corrections and their level of expertise in managing and housing inmates, with the ultimate goal of reducing recidivism and allowing these offenders, when they're released, to be law-abiding members of our society, which 9 out of 10 of them will be. And so we want to ensure that we're creating an environment that allows them to be properly rehabilitated and functioning. Again, I want to just reiterate that historically, the Department of Corrections, we have an 83%, the 3rd lowest recidivism rate in the country. And so much credit needs to be given to those experts who are managing people in the most challenging of circumstances. And so when they created this peer specialist program, they have, I think, inmates in mind who are of an age and of an experience and a level of wisdom and likely decades of good behavior that lend itself to really providing support for these young offenders in a way that is mutually beneficial to both the offender and to the aged inmate who is, wants to feel valued. And recognizing we have to lawfully and humanely incarcerate somebody with a long sentence that might be in for life. And there's probably no harder thing for that inmate to deal with than not being valued or useful anymore. And so to be able to provide wisdom and inspiration on a young offender, I think, is profound. And I do trust the Department of Corrections' ability to identify the correct inmates to be exposed to those youthful offenders. I don't know that I'd consider them being on general pop in Rollins. They probably are going to have an address located at one of our medium correctional institutions that really are willing and able to serve and have been properly identified. Again, I trust in the wisdom of the Department of Corrections to identify the right inmates for that and also to protect those useful offenders from any harm that may occur. But I fully think that this program is far better than those youthful offenders going straight into those penal institutions and being locked up in a pod in a unit. They're going to get exposed to far worse than the one or two senior inmates who are there to help. So the expansion of the program, it certainly appears that way on its face, right? We're now lawfully required to allow women in, and we've increased the age by 5 years. The Department of Corrections really is not particularly worried about quote unquote an expansion of the program. When we look at the demographics associated with these inmates who would be eligible or who's committing crimes in our state, it really still is predominantly men. There's going to be a minority, I think, of females who are in this age group and that would want to go to the youthful offender program. And so just by sheer numbers of female convicts, defendants who would be going into the program, that's going to not be as a significant concern. But that said, they still have a limited capacity. So I think the application process getting admitted into the program is more rigorous. So because there's going to be competing room for the same amount of beds, they can only take in 56 now and in the future. So there might be some offenders who don't get into the program. And I think we can assess that at that time. Right now, as I think as the good former member of the Judiciary Committee from Platte County or Converse County identified, we should applaud the Department of Corrections for being adaptable, recognizing that what they have done historically is no longer working to achieve the high success rates that they were accustomed to seeing. And so they're changing their practices. They're responding to a changing time. And this is the program they've asked to change it into.
Further discussion or questions, or are you ready for the question? Sensing you're ready to vote. Folks, I'm going to do as our colleague Senator Case did. Rather than get an exact count on committee of the whole, I'll simply declare whether it's passed or failed. If I'm uncertain, I'll call for a division and we'll actually count the hands. But if you disagree with what my call on it is, then be sure to call for a division. Ready for the question. All those in favor of Senator Nethercott's motion that when the committee of the whole rises to report, that do so with a favorable recommendation of House Bill 34, please raise your hands. Okay, all those opposed, same sign. House Bill 34 has passed the committee of the whole. The next bill for our consideration is House Bill 42. The clerk will read the House bill.
House Bill 42, Chancery Court Vacancy Amendments, an act relating to courts, sponsored by Judiciary. It was referred to Judiciary that returned a recommendation that it do pass, voting aye, Senators Cooper, French, Cole, Costa, and Nethercott. Signed, Tara Nethercott, Chairman.
You've heard the reading of the bill. What is your pleasure?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the do pass recommendation on House Bill 42, Chancery Court Vacancy Amendments. Good senators, just for your ease with this rocket docket we're underway, you're going to be looking at the engrossed version of the bill as you see it on the screen. To explain this good little bill, I refer to Senator French.
Senator French.
Yes, good senators. This is House Bill 42, Chancery Court Vacancy Amendments. This is sponsored by the Select Committee on Blockchain, Financial Technology, and Digital Innovation Technology. This is a bill, it's an act relating to courts, amending requirements for filling Chancery Court vacancies and providing for an effective date. be it enacted by the legislature of the state of Wyoming, Section 1, Wyoming Statute 5-13-109 is amended to read, and 5-13-109, temporary assignment to fill vacancies, appointments to fill vacancies in office. If you take note on lines 12 through 14, that's where it's amended. 5-13-109 B is amended, and it says beginning March 1st, they scratched out 2022 and put it as 2023. The office of the judge of the Chancery Court and any vacancy therein shall be filled as provided by Wyoming Statute 5-13-107. Section 2, this act is effective July 1st, 2021. My understanding of this, having never been a part of these discussions, so, you know, bear with me a little bit here, I'm a bit behind the 8 ball. In the legislature in 2019 has apparently been talking about this for some time. And in 2019, they passed a bill and appropriated for the 2021 biennium $1.1 million to get the Chancery Court up and running. My understanding is that right at this moment, it's not fully up and running. So I believe the appropriations cut the budget in half. So this amendment, where it has the effective date of 2023, March 1st, 2023, in the next biennium, the cost will be, instead of the 1.1 million, we were told this morning, it'd be roughly $900,000. Now, why is that? It's because of the delay of approximately 8 months to get a chancery judge in place and all the assistance and everything else up to speed. So in the next biennium, it won't be the full 1.1, but being new to this, I think this will have to be looked at probably in the future, because once you get a court, anything new like this up and going, there's going to be changes, additions, deletions, whatever. So that's my understanding of it. And thanks for the good senators for humoring me where I've not been a part of this discussion.
Questions? Senator Scott.
Mr. Chairman, this is an important bill with some big money at stake. We've gotten, as we've modernized our corporation laws, we've gotten into the business of being one of the states that residents of other states go to incorporate any number of particularly smaller businesses. We aren't competing with Delaware for the really large publicly held corporations, but we are competing with Nevada and South Dakota, as well as Delaware, for the business of the smaller corporations. And we've either ranked second or third in recent years in that. And the Secretary of State's office is earning the general fund. I think the total is in the vicinity of 20 million a year. And I don't know how much of it comes out of these smaller corporate incorporations, but it's something less. But it's bringing a fair amount of business here, a fair amount of revenue to the state. And the Chancery Court is something that, particularly as you get into the businesses that are slightly larger than just the really small ones, that's something they look to because it enables them to get justice quicker and from a court that's used to dealing with the business law issues. And so I think, Mr. Chairman, it's very important that we look at this not just in terms of the budgetary savings from not having the court, but in terms of getting it started quicker will make us more competitive and bring in more revenue and be more profitable. And frankly, Mr. Chairman, I've thought that the really smart thing for the judiciary would be to go out and try to hire an experienced Chancery Court judge away from some other state that's got them, and there are a number of other states that do that. But be that as it may, I'm quite concerned of why the initial proposal was to 2026. I think we may have seen great wisdom coming over from the other side. I can see why we need to delay it a year, perhaps because of the disruption that the COVID has caused. But how much assurance do we have that we'll really get this going and working on time? Because we do have significant revenue at stake here.
Thank you. Mr. Minority Floor Leader, I thought I saw your hand.
Yes, thank you, Mr. Chairman. I did want to address that particular point with regard to delay. This is one of those circumstances where the legislature created this. This is a very good, very useful, very important, I think, feature of our business and economic development endeavors that we've been looking at, particularly in the finance sector. That's why it comes from the Blockchain Select Committee. We've heard about the importance of this, and we have been working on it for a few years. And Judiciary Committee did some excellent work over the last few years. The former president was heavily involved in that to get this effort moving forward. Regrettably, the challenges are that while we created this, we're also to some degree holding it back from the financing standpoint and from providing the availability of funds. Based on some challenges with getting it stood up in a timely and cost-effective manner, there was effectively a request to just delay the transition timeline. The Select Committee came back with 2026. There's no hard, fast reason for that date. We just wanted to make sure that we were providing sufficient time to get to the objective, recognizing again that there is an economic downturn and that we're revenue constrained and that we didn't have any clear timeline on how quickly it would come up. So I think, to the good tall senator from Natrona County, I can assure you that the Select Committee would like to already have it stood up. We would prefer that this bill not exist and that we already be to the point where we have a working, effective Chancery Court that does all the things that we wanted it to do. But we're not there yet. And this bill ensures that we don't end the program and that we continue to facilitate it. And I know that we've got other members that have worked very hard on the Chancery Court and can also weigh in support and maybe contemplate the timeline. But again, to the good tall senator from Natrona County, I certainly don't know what the right date is. Clearly, it's not 2021. But I think that is a great point for consideration and discussion, is trying to think through what that should be. And I think the former president, I'd like to hear his thoughts and others on that as well, since we didn't have an opportunity to contemplate that as we worked it through the Select Committee. Thank you, Mr. Chairman.
Senator Cost and then Senator Perkins.
Thank you, Mr. Chairman. All of these concerns are great. It was moved down to 22-23. One of the benefits that we found out in talking with the district clerks was that, clerks, not the district ones, the judicial ones, is that the district judges have stepped up to say that they will assist in these until we can get it up. And they're also, we know that they're heavily laden with work, and so they're willing to step up because of the challenges right now. And so 22-23 can open that door for us to be able to seriously look at this, and they will try to handle everything up to that point, which means it's not stalled out. It's going to go ahead and move some more. I think they'll be very careful in what they're doing, but it looks positive in at least a starting growth. And then from there, we might be able to move into getting a chancery judge and getting that court in operation. But I just wanted everybody to know that right now the district judges have stepped up to the plate to help out until that time.
Thank you. Senator Perkins.
Thank you, Mr. Chairman. Mr. Chairman, I was the prime sponsor on this bill that brought it before. I can tell you that I've been in pretty consistent communication with the Supreme Court and the Supreme Court justices who've been working on standing this court up. The rules were, I think, just approved last year. I think COVID put a little bit of wrench in the work. Anybody who is involved in the judicial system right now knows that the number of hearings and jury trials, and of course you don't have jury trials in Chancery Court, but all of those things have been slowed down a little bit because of COVID. This was primarily a budgetary concern. The Supreme Court came to me and they were looking about where could they do something to assist in the level 1 and level 2 budget reductions that the governor was trying to get, and how do they participate in that? The district courts, or excuse me, the judicial system is a little bit hampered, as our few agencies in our government, about making those cuts, in that about 90, probably 90 or a little bit more than 90% of their budget is tied up in personnel. It's in clerks, it's in judges and IT people, and a few support people, and then some reporters. And so in doing this, one way was to push this back a year or so, to not put that judge in right now. In the meanwhile, when we did this and initially passed this, we allowed for until a person who's appointed to be the Chancery Court judge is appointed in the previous in a different section since actually in section A of 1513-109, we allow a retired Supreme Court justice, a retired district court judge, or a member of a panel of up to 5 active district court judges selected by the Supreme Court can serve as Chancery Court judge on an ad hoc basis. So we have the ability to stand this up now. We have the ability to go back, and any judge who's interested can serve on an ad hoc basis as a Chancery Court judge now. Again, I think one of the issues that people have struggled with was this was a paradigm change, in that the original statute requires or sets out as a goal that cases will be resolved within 150 days of filing. And that's a huge paradigm shift for most people in the legal profession. And I think judges and even attorneys are struggling with the fact of how fast this docket is going to be, and how they have to be prepared at filing or shortly thereafter to come and present their evidence to the court and start to seek a resolution. So in this fact, it's pushing us off a year. I think will probably slow down building the expertise in-house. But nevertheless, we do have a number of even retired district court judges, Supreme Court judges, and existing district judges who would meet the requirements of being a Chancery Court judge that can participate. And so my hope is that we start to have cases filed in this, and we start to see cases in it this year, because we need to move forward. I think the budget is that we would go ahead and stand up our clerk, so that we can have the clerk of this court begin to work those cases, be able to accept the filings and get things moving on this, and then organize and distribute the work among judges who are participating on an ad hoc basis. But this, when it comes back, particularly for the new members, when you get to the budget, you'll see that every district court in the state is its own agency, and the district courts run right around $1.2 to $1.3 million a biennium to run a district court. This is a district court level, intended to be a district court level on basically the same level as district courts. Appeal from this court is directly to the Supreme Court, and so in doing that, it'll probably the budget will be fairly consistent with what you see in district courts when it comes out. But it's going to be important to move this forward, particularly for all the reasons that my good senator, the much taller senator from Natrona County, has mentioned, as well as our minority floor leader. Thank you, Mr. Chairman.
Thank you. Are you ready for the question? Senator Scott.
Mr. Chairman, I would suggest that as we go forward with this, if there's further proposals, we need to look at not only the budgetary side, but talk to the Secretary of State's office and particularly talk to some of the attorneys whose practice is focused in this particular area, and make sure that trying to save a few dollars, we aren't foregoing more revenue than we're saving, because this is a major, we're talking about, in these incorporations are a major revenue source now for the state of Wyoming, and it keeps growing. And this is an important feature in being competitive there.
Thank you. Further discussion?
Question.
All those in favor of Senator Nethercott's motion that when the committee of the whole rises to report, that it do so with a favorable recommendation of House Bill 42, please raise your hands. Okay, thank you. All those opposed, same sign. House Bill 42 has passed the committee of the whole. The next bill for our consideration is House Bill 3. The clerk will please read the House bill.
House Bill 3, Certified Addictions Practitioners Certification Amendments, an act relating to mental health professionals, licensing and certification, sponsored by the Labor Committee. It was referred to Labor, Health, and Social Services Committee, who returned a due pass recommendation to the Senate, voting aye Senators Baldwin, Bouchard, Furphy, Hutchings, and McCune. Signed, Senator Baldwin, Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman Baldwin?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the recommendation that House Bill 3 do pass. For an explanation of this bill, I would turn you to the good senator from the capital city, Senator Bouchard.
Senator Bouchard.
Mr. Chairman, point of procedure.
Senator Perkins.
Thank you, Mr. Chairman. I note that in trying to pull this up, that this particular bill is not in the engrossed state on the website, at least the one I pulled up. Doesn't appear to be the engrossed state, and so it'd be helpful if the proponents of the bill would help us understand what the House amendments did, since we don't have the advantage of seeing the engrossed version in front of us right now. Thank you, Mr. Chairman.
Thank you. Hang on a second. I'm looking. You're right. I'm not seeing an engrossed version, and there were House amendments.
Mr. Chairman.
Clerk Ellen Thompson, Chief Clerk, please.
Mr. Chairman, there were House amendments, but one was withdrawn and one was failed. Therefore, the bill was not amended.
Well, I knew there'd be an easy answer. All right. So, thank you. Thank you, Chief Clerk Thompson. Senator Bouchard, continue.
Thank you, Mr. Chairman. Was the bill read in?
It was, and it was moved. And
Okay,
now you're presenting it.
Thank you. Yeah, so let me go over the bill. House Bill number 3, Certified Addiction Practitioners and Certification Amendments. What's going on in this bill here as we go down the bill? What we're doing is allowing the the board to go and use a lot of the things that we've talked about in the past, and I'll go over. I apologize, Mr. Chairman. I'm kind of lost my place here before we started. So what this bill does is it allows the board to be more broad in how it allows licensees to come on board. And so when we go down the bill, I'm just going to skip to the page 2 here. And on page 2, starting in line 1, and let's go down line 15. We're using the national standards for accreditation in the field of addiction therapy as accepted by the board. So what's happening there is the board actually has to look at those standards and accept that. So it's internally, there's control in the board. It also has a standard on 16 that the board has received a proof of a bachelorette. On line 18, in performing its duties in this paragraph, the board shall consult the professional training experience standards of the National Professional Associations. So that's really in a nutshell what's going on here. We're allowing the board to make an educated decision on how they're going to move forward and allow practitioners. As we go to page 3, what we're doing on this part of on starting on line 1 is we are allowing a person with a bachelor's degree in human behavioral discipline or other degrees in addiction therapy, and they may be granted certification under this section. Again, we're allowing the board to look at the proof of completion of 2,000 hours of supervised work experience as a certified addictions practitioner, assistant, or equivalent in the field of addiction therapy. So in a nutshell, what we've had in the past is a problem where the codes that were already in place were causing a conflict where the board was under strict scrutiny to do things that maybe they couldn't do, and we were having conflicts on all around. So I mean, this bill is going to wrap that up, and I will stand for any questions.
Questions? Senator Landon.
Thank you, Mr. Chairman. And I guess the question that I have to the senator is just related to the language change in the bill. We go from allowing a baccalaureate degree in human resource discipline, and it's narrowed dramatically to a behavioral addictions sort of discipline. And I wonder, is that as much a result of advancements in the field of addictionology, or is there something else at play here with regard to what we want that board to be focusing its attention on? So that's my question. Thank you.
All right, let's go ahead and get other questions and present them to Senator Bouchard at once. Were there other questions? All right, Senator Rothfuss.
Thank you, Mr. Chairman. Yeah, just a general question of kind of the 50,000 foot explanation of what this is going to accomplish. It seems to me that we have seen similar concerns in the past and tried to address it and been unsuccessful. So I'd just like a quick summary of what this is going to change from a practical standpoint, an overview summary, if I could hear that, Mr. Chairman. Thank you.
All right, Senator Bouchard. Senator Bouchard, you're muted.
Sorry, Mr. Chairman. I pushed it and it didn't work. I think I can answer both of those questions in a pretty quick summary here. So there are multiple people that can already kind of practice in this scope. So for instance, you have social workers that can practice there. There's also what we're also looking at the future use. There are some other degrees that are allowed. For instance, you take in corrections, you may have someone who, and I'm not saying that the board has made this decision, but what we want to do is make it to where the board can say, hey, this person has a criminology degree and has X amount of experience. Can we use some of that experience, in moving them forward in drug addictions? But if you look at the different degrees that can practice in mental health, all of them don't all fit under one title. So in a nutshell, that section on page 3 will allow the board to make those decisions and bring people into the fold. So it kind of solves all the problems that we've had in the past trying to do this with much larger legislation. And I'm sure if anybody has been here long enough to remember that, I mean, it's been an ongoing thing. This solves the problem in a simpler bill, moves us in a direction to allow the board to make changes in the way they accept licenses.
Further questions or comments, discussion? Seeing none, I sense you're ready for the question. All those in favor of Senator Baldwin's motion that when the committee of the whole rises to report, that it do so with a favorable recommendation of House Bill 3, please indicate aye by raising your hands. Thank you. All those opposed, same sign. House Bill 3 is passed committee of the whole. The next bill for our consideration is House Bill 6. The reading clerk will read the House bill.
House Bill 6, Trust Company Amendments, an act relating to trust companies. Sponsored by Minerals. It was referred to Minerals, who returned a recommendation that it do pass. Voting aye, Senators Cooper, Rothfuss, and Wasserberger. Anderson absent, Weitman excused. Signed, Jeff Wasserberger, Acting Chairman.
You've heard the reading of the bill. What is your pleasure, Chairman or Senator Wasserberger?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with a favorable recommendation that House Bill 6 do pass. And I will turn the bill over to the floor manager, the good senator from, I believe, Washakie County, Senator Cooper.
Senator Cooper.
Thank you, Mr. Chairman. I'm here today to lead us through House Bill 6. It's a bill regarding expansion of trust and mergers and acquisitions within the state, an expansion of the banking board within the state. As you're all very aware, the state of Wyoming has become a real leader in the
Senator Cooper, hold for just a second. Senator Cooper. Senator Wasserberger, could you mute your microphone, please? There you go. Thank you. Senator Cooper, please continue. I'm sorry for the interruption.
No problem, Mr. Chairman. Okay, anyway, we're talking about the trust industry within the state has really experienced some very robust growth in the last years as Wyoming continues to grow its reputation as the leading jurisdiction in wealth transfer planning across the nation. So this bill addresses several things, a couple things. It starts out with inserting section 1, if you will, in starting on page 1, and that flows all the way through page 9. And what that does, it establishes procedures for mergers and acquisitions in the trust business so that we can continue to grow our trust business across the country and continue to bring these large trust deposits to the state. It's a pretty extensive thing for establishing these procedures, but it's very well written. The language was gathered from a lot of different sources, but it is the proper language is my understanding of it now. I'm not a trust expert by any means, but I do trust the Banking Commission. The second thing that this does is it amends the membership on the Banking Commission. If you go to page 10, I believe it is. Somebody misplaced my mouse here. Page 10 addresses that. They're going to increase the Banking Commission from 7 members to 8 with the addition of a representative from the trust industry. 5 of the officers will be directors of state or national banks. 1 will be a member from the trust industry, and then 2 members from the population of the state. So again, that's what that purpose is. The next section of the bill on page 10, I believe it is. Nope. Page 11 discusses definitions, and it means a few of those definitions, but it's really just cleaning up language. The next portion of the bill that's really pretty critical to us is the also on page 10, addresses insolvency of these trust firms, and it gives the State Banking Commission the ability to lead these firms into bankruptcy court rather than having the state forced to take receivership of these firms. It can be, the receivership can be extremely expensive, and this section on lines 14 through 18 on page 11 addresses that and gives us the ability to redirect that to bankruptcy courts and taking the burden off the state of Wyoming. There is on page 12, excuse me, organization of family trust. It amends the family trust mechanism just a little bit and discusses the requirements of family trust for meetings. On the fiscal side, there is no significant fiscal or personnel impact to the state. So all in all, it's a pretty straightforward bill. The biggest two things is the ability to establish procedures for mergers and acquisitions so we continue our massive growth in this division, and also amend the Banking Commission to from 7 members to 8, so we can have a member of the trust industry on the Banking Commission. Thank you, Mr. Chairman.
Thank you, Senator. Questions? Senator Hicks and then Senator Nethercutt.
Yeah, Mr. Chairman, real quick question. As I look through this, if we go, I'm curious, as now we have an even number board. I understand bringing in the new public trust company as a board member. On page 10, so if you go to page 10, slide 7, I don't know that I've heard an adequate explanation as to why they expanded the number of board members to include one more from a state or national bank, which now creates an even number on the board. Why are we adding another representative from the state or national bank to this board and creating an uneven number of individuals on the board?
Okay, there's one question. Next, Senator Nethercutt.
Thank you, Mr. Chairman. I do share those concerns as well associated with the number. But then just a question that I find curious, and I don't know the answer to, but on page 11, lines 14 through 18, I just want to bring to the body's attention, because so often it is alleged on judiciary bills for how it would ever be interpreted, but who determines best interests. But I think it's just fun. I'm just pointing that to your attention. But a receivership is something that occurs as a result of being domiciled in the state and choosing to be regulated by the banking division. And it's something that the banking division has the power to do. But I am not aware of whether or not the banking division can force a company to file bankruptcy like this. And is there precedent for this anywhere? I mean, essentially receivership is bankruptcy, I get it, but is a different animal. I'm just curious about the precedent associated with that anywhere else in the country.
Any more questions before I turn it over to Senator Cooper, Senator Wasserburger, and then Senator Rothfuss?
Thank you, Mr. Chairman. Just to response to the questions on section 13.1604, where we expand the board. essentially that question came up before the interim committee, and the director of the banking division said that an even number of the board, he had never seen a situation where there was even a close vote, and he anticipated no impact as a result of that. But really the reason why we are increasing the number is so that we can have representation from our national banks. And then and so that's the answer for that. And so I will let the good senator from Albany County answer the next few questions.
So Senator Rothfuss, I didn't realize you had I didn't know whether you had questions for Senator Cooper, or go ahead, Senator Rothfuss.
Mr. Chairman, I'm here to answer questions as well,
Okay.
and I'd be happy to take others to stack them up if they're out there.
Further questions? Senator Furphy.
Thank you, Mr. Chairman. Let me ask about, first of all, can these trust companies also be part of a bank and not separate from a bank? And then my other question is, where it says on the directors that it should be a state or national bank domiciled in Wyoming. What does that mean? Does that mean it can be an out-of-state bank who has a branch in our state? Because quite honestly, we have very few actual national banks whose headquarters are in Wyoming. So those are a couple of my questions, Mr. Chairman. Thank you.
Okay, any more before I turn it over to either Senator Rothfuss or Senator Wasserberger for answers? Okay, Senator Rothfuss, please.
Thank you, Mr. Chairman. Mr. Chairman, appreciate the questions and discussion. And I'll just run the list and clarify a couple of things. As we look at the page 10 updates to the state banking board, there were 3 different concerns that were discussed there. The first is going to an even number and having a majority. It would simply be that 5 members would be the majority. We've got an even Senate and it works out just fine. And the concern was honestly by the banking division, they didn't need a 9th person and they didn't feel they needed a 9th person. So they were just trying to keep it lean, but get somebody from a trust on there. And it still works. And as they pointed out, as the good senator from Campbell County pointed out as well, they're mostly unanimous on their votes. They want the expertise more than they're worried about narrow votes. With regard to the question about specifically changing and adding from 4 to 5 members of the state or national banks, when you read the language in its entirety, there's a lot of shuffling around here. Right now, there's a requirement that there be 4 members, directors, officers of state banks, 1 national chartered bank, and nobody from the trust realm, and then 2 other members who are not related to a banking or trust company. When you sort out all of the changes, what happens after the fact, Mr. Chairman, is that there would be 5 members of banks, same as now, but it's simply an or clause, state or national. And it actually gets to the point of my good colleague from here in Albany County, a former banker, where the state board is having challenges looking forward in the future to nationally chartered banks because our state domiciled banks tend to all be state chartered because quite honestly, we do a better job. And so as a result, the or statement is being put in place. There's no increase or decrease in membership by banks. It's just the recognition that state domiciled banks tend to be state chartered banks at this point. And no, it can't be an out of state bank it has to be domiciled in Wyoming. Actually, the domiciled in Wyoming means it's a Wyoming corporation. I don't know if we have any circumstances where we have out-of-state state chartered banks that are domiciled in Wyoming. That's an interesting question that we can look into. I'll follow up on that. That might be a thing, but I don't think it is. With regard to the receivership question by the good chairwoman of the Judiciary Committee, page 11, lines 14 through 18, as determined by the commissioner. There's two concepts there. It is the commissioner's discretion, and the commissioner manages and handles the same things with regard to bank solvency already. So this is mirroring language elsewhere in statute for the judgment of the banking commissioner with regard to appropriate path forward for insolvency and the supervised receivership of a state chartered bank, trying to mirror that over on the trust side. With regard to whether this has been done or whether the power is there, that's not a question we asked, and I don't remember having any discussion about that. So that'll be the second thing I'll follow up with the commissioner on, to find out and learn whether this is something that actually has specific precedent and has been done before. I don't know that answer. And then the final question from my good colleague here in Albany County is whether these trust companies can also be part of a bank. The bank can serve as a trust, and it's still going to all fall under the Banking Commission's regulation of the banks and their trust responsibilities as banks. This is specifically supervised trusts that are not chartered banks, and making sure that we've got the right provisions for mergers and acquisitions and a lot of the things that we already have for state chartered banks as we extend our supervised family or supervised traditional trust portfolio. It's just some pieces that were deemed to be missing with regard to the insolvency and the mergers and acquisition. Mr. Chairman, I think that addresses all the questions, or at least I'll try and address those that I didn't have an answer to moving forward, and happy to answer any other questions.
Thank you, Senator Wasserberger.
Well, thank you, Mr. Chairman. I mean, I just wanted to maybe reiterate at this time that the Minerals Committee has been working on the trust company statutes. If you recall, we had a bill 2 years ago. And so really the only thing that is at least changing within the bill is the actual representatives on the state banking board. And we've been quite successful actually of recruiting and actually getting banks to the state of Wyoming. I will draw your attention to the very last page of the bill, where we allow family trust companies, and they will be allowed to meet once. They can meet once, up to more than one time a year, but required to meet one time a year, but they can also meet as we are today by Zoom. So I think it's a good little bill, and I hope you support it. Thank you.
Further questions and discussion, or are you ready to vote? Question. Are all those in favor of Senator Wasserberger's motion that when the committee of the whole rises to report, that it do so with a favorable recommendation of House Bill 6, please indicate by raising your hands. Thank you. All those opposed, same sign. House Bill 6 has passed the committee of the whole. The next bill for our consideration is House Bill 8. The reading clerk will read House Bill 8.
House Bill 8, Consumer Credit Amendments, an act relating to trade and commerce. Sponsored by the Minerals Committee, it was referred to Minerals Business and Economic Development, who returned a due pass amended recommendation back to the Senate. Voting aye, Senators Cooper, Rothfuss, and Wasserberger. Senator Anderson absent. Senator Brightman excused. Signed, Senator Wasserberger, Acting Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Wasserberger, Acting Chairman?
Thank you, Mr. Chairman. I move that when the committee of the whole rises to report, it do so with the favorable recommendation that House Bill 8 Consumer Credit Amendments do pass. There is a standing committee amendment, which I will move at this time.
Point of order, that needs to be read in and then
Oh,
moved.
I'm sorry, can we read that in, please?
House Bill 8, Standing Committee Amendment Number 1, 2 engrossed copy, page 2, line 9.
Senator Wasserberger.
Thank you, Mr. Chairman. I would move Standing Committee Amendment Number 1 to House Bill 8 and explain it at this time. Members of the 66th Legislature, this is a technical correction that was brought to me as acting chairman by LSO staff attorneys. And essentially what it says is on page 2, line 9, after days, delete of and insert after. And if there are no questions on this technical correction, I would call the question.
Any questions? If not, all those in favor of Senator Wasserberger's motion to adopt Standing Committee Amendment Number 1 to House Bill 8, please indicate by raising your hand. Thank you. All those opposed, same sign. Standing Committee Amendment Number 1 has been adopted. We're back on the bill. Senator Wasserberger.
Thank you, Mr. Chairman. I would call on the outstanding senator from Albany County to walk you through this cute little bill.
There he is. Senator Rothfuss, please.
Thank you, Mr. Chairman. One of the outstanding senators. We've got another great one, but Mr. Chairman, I'll be the one to walk through consumer credit amendments today, House Bill 8, to the engrossed copy, Mr. Chairman. And as a little bit of a background, the Uniform Commercial Credit Code, the UCCC, was adopted in Wyoming in 1971. It was prepared as a uniform law in 1968. We adopted it in 71, and we really haven't changed it very much in that 50 years intervening in terms of the content and modernized it. We've changed some of the numbers of when it applies, but we really haven't done much else. And most of this bill is non-substantive cleanup. So it's a long bill with a lot of nuances, but most of it really isn't policy change. And I'll try and highlight separately those things that are policy change as opposed to just trying to clean up our language. There are two key concepts that are resonant themes throughout this legislation. The first is a substantive policy, which we're going to start right off the bat with, which is a change to a refund of a certain type of credit insurance or product. And we'll see that at the bottom of page, or beginning of page 2, where we have a refund requirement provision. And I'll get to that in a moment, and then we'll have some conformance with that. But then the other key concept that comes up a number of times throughout is the idea of a previous delineation in the original Uniform Commercial Code, Uniform Commercial Credit Code, excuse me, where consumer-related loans and supervised loans were treated separately. And the threshold was simply a 10% annual percentage rate. So if you were below 10%, it was called a consumer loan. If it was above 10% interest rate, it was called a supervised loan. And a substantial portion of this bill, including most of the repealers, simply merges those two concepts into one. They're all consumer loans, and then conforms the language because they weren't in any way regulated differently, but there were two entire sections of statute to cover what is effectively the same concept. And the final point of background, Mr. Chairman, that I would say is that as we contemplate these consumer loans, the thing that you can have in mind that is probably the easiest case study is your vehicle loan. Right now, these consumer credit loans are less than $75,000, and you'll see that in statute as we go through it. And this is a credit protection system for those loans of $75,000 or less, and the regulatory structure to protect consumers for those loans. It would also be for other types of credit, but that's one that we're most commonly dealing with. So with that background, Mr. Chairman, walking through the bill, page 2 and on to page 3, this is new policy, this 454 section here, refund of certain credit insurance products. The key provision here that you see in paragraph A is the idea that if there's a termination of this product, that there has to be a refund of the outstanding pro rata interest in that product within 60 days, as you can see there in paragraph A. And then paragraph B indicates that the calculation of the outstanding balance for that product will be calculated on a pro rata basis, or as you see in lines 4 through 6, on an alternative basis that reflects the remaining risk if authorized and defined by rule of the administrator. So the baseline is a simple day count pro rata, but if there's a reason why the risk is not
Senator
linear
Rothfuss?
over the time. Yes, Mr. Chairman.
I'm just going to interrupt you for just 2 minutes. Senator Nethercutt, could you take the chair for a bit?
Yes, Mr. Chairman.
Madam Chairman, continuing.
Please, Senator.
So the standard is the pro rata basis, but if there's a justification for an alternative risk basis, that would be allowed by the B paragraph. So as a bit of background and understanding, what are we talking about here? There are concepts, for example, one that we discussed would be gap insurance, where you purchase a vehicle and you purchase a separate product, which is an insurance product on that vehicle that covers the gap of the equity. So if you total the vehicle, and for example, you only get $15,000 based on the totaled cost, but you have $18,000 left on your loan, that $3,000 upside down gap would be a potential product that you could purchase insurance on at the time, often when you're purchasing the vehicle. So this type of product is what we're talking about when we're looking at this paragraph 454 here. And the idea that if you wanted to cancel that insurance policy, or if some termination event came into effect, that you would have to be refunded within 60 days, and it would be on a pro rata basis unless otherwise justified. Moving on, and to be clear, that's effectively the new policy. That's new. Everything else is an amendment of existing policy and conformance. As we get into page 4 and moving into the discussion of the consumer-related loans, basically everything we see for the next, I think, probably 20 pages, but we'll go through it, is this idea of conforming the language, which you see on lines 8 and 9, where we have consumer-related sales and loans, and we're merging those with the supervised loan, and that's going to be taking place throughout. So page 4 is conforming language. Page 5, again, is conforming with other provisions, as well as a definition of what you see as regularly engages or regularly engaged, which is, again, conforming with current practice and updating the statutes. You see on page 6, again, reference to those new definitions. On page 6, the new paragraph B is the idea that there is a requirement in effectively existing rule and regulation that you must register any of these articles of consumer credit sales and be registered with the Division of Banking. So this puts that requirement in statute. Page 7 at the top is conforming language. The bottom is a change. It's basically an inflationary adjustment for the maximum amount of administrative fee that can be charged for the administrative side of preparing the contract for this credit service, changing it from 50 cents per month to $3 per month. And that's effectively my understanding is it hasn't been changed since 1971. I could be wrong on that, but it's basically an inflationary adjustment. $3 is what it's being changed to. Page 8, again, is conforming language, but it's also specific reference to the federal provision for a veterans. Let me get the exact language. This is the U.S. Code 987 on page 8, lines 14 and 15, is the Military Lending Act. So it's conforming provisions with the Federal Military Lending Act that's being put into statute with an explicit reference. Bottom of page 8 is conforming language. On page 9 is again conforming language with the supervised versus the non-supervised bills, or the consumer line. Page 10 is again consumer related loans and supervised loans. Page 10, lines 21 is updating the reference to clarify, and this gets into a reference to a first lien concept, which is not covered. First lien on a mortgage, home mortgage, which is not covered by this provision. And it's explicitly making sure that that carve out is acknowledged. You see that further clarified on page 11, paragraph C, where there is now an explicit carve out related to the fact that the loan primarily secured by an interest in land is going to be covered by the mortgage lien statutes as opposed to this section, even if it's less than $75,000. So that's a clarification that's consistent with current practice. Page 12 is conforming language, and going to current practice on pages 13 and 14. Gets back again to the consumer loans versus supervised loans, and a reiteration of the administrative charge that we saw above. Conforming language going through, it's just deletion and conformance going through, I think, page 20 at this point, if I'm not mistaken. And then on page 20, we again have clarification regarding the Military Lending Act, specific to statute. Page 21 is just technical changes, again, dealing with the new existence of what we created above, 4014-454. This is a reference back to it for technical clarification. Page 22, interest in land, again, gets us back to the idea of the mortgage. Conformance, page 23 is conforming language, 24 is conforming language, 25, 26, but on lines 22 and 23 is an exclusion, and there's a little bit of contention here, and this is the other area where it is technically a policy change. Right now, nationally chartered banks are not subject to the transaction fee that the Division of Banking charges with regard to this UCCC code filing, whereas state chartered banks are. So we basically bill state chartered banks more than nationally chartered banks since they're not subject. So this removes state chartered banks and exempts them from the fee as well to create parity between the state chartered and nationally chartered bank. The one little hang up on that, though, which has created some consternation, but nobody can come up with a quick solution, is that it then simply puts the burden for paying that fee back on the originator of the loan. So if you're buying an automobile, for example, then the fee will end up being paid by the loan originator, which is going to be the dealership or the individual. So it exempts the banking institution, but the fee will still end up being paid in some circumstances. So it's seen as a bit of a cost shift. Page 27 is again conforming language. Page 28 is conforming language with an awful lot of repealers. I have all of the details of the repealers in front of me, but made sure that it was consistent with all of the other policies and conforming, which is the case, that the repeals are based on primarily the difference, this merger of consumer-related sales and consumer-related loans, and then the supervised loans and sales as well, merging those two. Plus the repealer of language related to the loan primarily secured by an interest in land being related to a mortgage. And then there are a couple of provisions that have just never been used and are no longer needed to be effective that were put into our statutes back in 1971. For example, 4014, 701, and 702. So that's the bill. It is a long and detailed bill. It sounds like it's long overdue, trying to correct about 50 years of legacy statute. And if there are any questions, I'd be happy to try and address them at this point in time. And if I can't answer them now, I'll get back with the Division of Banking to provide further clarification, Mr. Chairman.
Questions for Senator Rothfuss? Questions or discussion? Seeing none, sensing you're ready to vote, all those in favor of Senator Wasserberger's motion that when the Committee of the Whole rises to report, that to do so with a favorable recommendation of House Bill 8, please raise your hands. Thank you. All those opposed, same sign. House Bill 8 has passed the Committee of the Whole. The next bill for our consideration is House Bill 9. The reading clerk will please read House Bill 9.
House Bill 9, Short Time Compensation Program, an act relating to labor and employment, sponsored by Minerals. It was referred to Minerals Business and Economic Development, who returned a due pass recommendation. Senators Cooper, Rothfuss, and Wasserberger voting aye. Senator Anderson absent. Senator Reitman excused. Signed, Jeff Wasserberger, Acting Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Wasserberger?
Thank you, Mr. Chairman. There is an appropriation on this bill, and I would ask that this bill be re-referred to Committee Number 2, Senate Appropriations, at this time.
Hearing no objection, the bill is re-referred to Appropriations Committee. The next bill for our consideration is is House Bill 48. The reading clerk will please read the House bill.
House Bill 48, Community Juvenile Services Block Grant Program, sponsored by Appropriations, an act relating to community juvenile services. It was referred to Committee Number 2, Appropriations, who returned a due pass recommendation. Voting aye, Senators Garreau, Hicks, Kinski, and Steinmetz. Excused, Senator Perkins. Signed, Dave Kinski, Acting Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Perkins?
Thank you, Mr. Chairman. Mr. Chairman, I move that when the Committee of the Whole rise and report, that it do so with a recommendation of due pass on House Bill 48, Community Juvenile Services Block Grant Program. And I was taking my wife to a doctor's appointment during the committee meeting today. Was there anybody who was assigned to do this bill?
I believe Senator Steinmetz took one giant step forward.
Thank you. With that, Mr. Chairman, I ask you to call upon the great senator from Lingle area, Senator Steinmetz.
Senator Steinmetz, please.
Chairman, to finish off the day, this good little bill, House Bill 48. Can everyone hear me all right?
I can hear you fine, Senator.
All right, thank you. Someone in the gallery thought they could not hear me, so I'll start over again. This is making conforming amendments to the governor's cuts, his budgetary cuts that we will be seeing in subsequent sessions. And so in your budget bill, it will be on page 18 of 40, and we are reducing their budget by $579,783. And so that is what this will do. The Department of Family Services had to have this change in order to make this reduction. And so basically we are just saying that the block grant will be subject to the availability of funds, because subsequent to that on page 1, line 15, it said the department shall administer a comprehensive state program. So we just had to subject that to the availability of funds. We're making another amendment in another section on page 2. Under the administration of the block grant, line 7, we're just subjecting that to the availability of funds. So that is what this bill does in short, and I would stand for any questions.
Questions or discussions regarding House Bill 48? Any questions or discussion? Sensing you're ready to vote, all those in favor of Senator Perkins' motion that when the Committee of the Whole rises to report, that it do so with a favorable recommendation for House Bill 48, please raise your hands. Thank you. All opposed, same sign. House Bill 48 has passed the Committee of the Whole. And Mr. Majority Floor Leader, Senator Hicks. Mr. Majority Floor Leader, that clears the desk.
Mr. Chairman, before we go to the Majority Floor Leader, we have another message from the House that I'd like to take care of. Madam Chief Clerk?
Mr. President, shall we dispense with the Committee of the Whole report
Oh,
first?
sure. Please, go ahead.
Chairman,
Senator Driscoll.
Mr. Chairman, I move that when the Committee of the Whole rise and report.
You've heard the motion. All those in favor,
No.
please raise your hands. Opposed, same sign. You've heard, motion carried. Mr. President.
Mr. President, you're muted.
Thank you. Madam Chief Clerk, we'll insert this message now.
Now, point of order.
Well,
We've closed out, though.
Point of
we'll
order,
read
Mr. President.
Go ahead.
Mr.
Go ahead,
President.
Senator Rothis, go ahead.
Thank you, Mr. President. We need to move for the adoption of the Committee of the Whole report now. We're out of Committee of the Whole, so that would be the next thing that's in order.
Okay, you've heard the motion. All those in favor say aye.
No, point of
Well,
order.
we need to read the report.
Yep, read the report, then move for the adoption.
Go ahead,
Yep.
Chief Clerk.
Boom.
Mr. President, your Committee of the Whole, having had under consideration bills on general file, begs leave to report as follows. House Bill 34 do pass. House Bill 42 do pass. House Bill 3 do pass. House Bill 6 do pass. House Bill 8 engrossed do pass amended. House Bill 9 re-referred to Committee Number 2. House Bill 48 do pass. Signed, Senator Kinski, Chairman.
Mr. President.
Mr. Chairman.
I move for adoption of the Committee of the Whole report.
You've heard the motion. All those in favor say aye. Those opposed? All right. Before we go back to the floor leader, Chief Clerk, do we read this in now?
Yes, Mr. President, messages from the House.
Please
From the House,
proceed.
from the House of Representatives, message number 120, February 1st, 2021. Third reading passed, amended. Mr. President, the bill listed below passed the House on third reading in an amended form by the vote indicated. House Bill 35, Theft Statute Amendment, ayes 60. Sincerely, Wendy Harding, House Chief Clerk.
Okay, Madam Clerk, Chief Clerk, then we'll read it in at this point. House Bill 35, first reading of the bill.
House Bill 35, Theft Statute Amendment, sponsored by Judiciary.
House Bill 35 is referred to Committee Number 1, Judiciary. All right. Mr. Floor Leader, that apparently now clears the desk. We had that little bill that just wanted in there. Okay. Mr. Floor Leader, what would you like to have us do? Can't hear you. Mr. Floor Leader, would
Mr.
you?
President,
There you go.
Senate resolve itself into committee of the whole. Go ahead and work the last bill.
Oh,
I read in. Just we'll clear it off. We got time.
well, it has to be referred to, it's been referred to Judiciary.
Oh,
Mr. Floor Leader.
okay.
I know you're anxious to get some more work done.
I am. Mr. Majority, okay. You need to tell me I cleared the desk again, I think.
It's cleared the desk. Mr. Majority Floor Leader, that clears the desk. When are you putting us back to work?
Mr. President, I move that we stand adjourned until 10 a.m. Tuesday, February 2, 2021.
All right, you've heard it. All in favor, 10 a.m. Tuesday.
Mr.
February
Chairman, Mr. President,
2nd. Yeah, go ahead.
announcements, Mr. President.
Announcements first.
Thank you, Mr. President. Your committee number 2, We Try Harder Appropriations, will be hearing the re-referral of House Bill 8 Short-Term Compensation Program as soon as we can gather after adjournment. Thank you.
Chairman Boner, how hard does your committee try?
Well, we'll find out tomorrow, Mr. Chairman, when we hear our committee bills. Committee number 5 will be hearing House Bill 44 on the bus water bill plant construction. House Bill 45 changes to water right notice requirement for hearings. House Bill 53 invasive plant species. Upon noon recess tomorrow, I'll try hard to enunciate my words, Mr. President.
We're tracking you. Appreciate your work.
Mr.
Chairman
President,
Case.
Point of
Chairman
order.
Case. Please do.
I heard a point of order.
Yes, point of order.
Point of order. The re-referred bill was referred to as House Bill 008. I think it's supposed to be 9, isn't it?
Let's double check. Thank you, Senator Cost.
I think that's right, Mr. President.
Okay, so yes, good correction. For the record, 9. Chairman Case.
Thank you very much, Mr. President. Your committee number 3, Revenue, will meet tomorrow, 30 minutes after the noon recess, to take up House Bill 30, Public Utility Assessment. We'll be in virtual land, and we'll look forward to having everybody there.
Thank you. Further announcements, Chairman Ellis, then we'll get over to the others.
Thank you, Mr. President. Tomorrow, committee number 6, Travel, Recreation, Wildlife, and Cultural Resources will take up House Bill 66, the 2021 Large Project Funding Bill. And I think that's it. Thank you, Mr. President. At 8 a.m.
8 a.m. Senator Driscoll.
Mr. Chairman, your committee number 7, Corporations, Elections, Political Subdivisions, will meet tomorrow morning at 8 o'clock to take up House Bill 13, Alcoholic Beverage Regulation, House Bill 27, Business Code Revisions, and House Bill 15, Department of Transportation Communications Facilities, if introduced and referred.
Thank you. Chairman Landon.
Chairman, thank you. Your committee number 8, Transportation, will be meeting 15 minutes after adjournment tonight to take up House Joint Resolution 1, traumatic brain injury and post-traumatic stress treatments. House Bill 18, military training memorials. And House Bill 25, tribal vehicle registration exemption implementation. Mr. President, once again, 15 minutes after adjournment tonight. Thank you.
Thank you. Further announcements? Further announcements? All right, you've heard the motion. All those in favor say.
Mr. President, you've got a couple of hands up.
Oh, gotta wave them. Go ahead. Chairman Landon.
Mr. President, thank you. And I'm sorry to belabor and keep people, but we had a couple of senators who presented their first bills this afternoon. I thought they did a great job.
Yeah.
We're not all there to be able to pat them on the back. So good job to our senators.
All right.
Mr.
Thank
President.
you. Good point. Thank you. Go ahead.
Mr. President, just a privilege of the floor.
Please.
Speaking of which, I heard some of the newer senators adopting a bit of nomenclature originally introduced, as I recall, by Senator Nethercott, where you address the body as good senators. And I just want people who are adopting that bit of nomenclature to be aware that in so saying good senators, they might well be addressing less than a majority of those in the room at the time.
Editorial opinion. All right. Very good. Senator Chairman Ellis.
The privilege of the floor.
Please do.
Just briefly, I just want to give a shout out to our Legislative Service Office. I know I had been working with them very, very closely last week. They're working really hard. So I know you're listening, Elissa. We really appreciate everything you're doing right now for us, as well as session staff that's getting us through this. Thank you.
Yes, indeed. Working hard behind the scenes. We appreciate all they do. All right. Thank you. Chairman Nethercott.
Thank you, Mr. President. Just let me know if another time would be prudent, but just a question about logistics for the remainder of this week. The Judiciary Committee's just been assigned another bill. We would love to hear that bill. Will we be able to schedule a meeting for Wednesday morning?
Not opposed. If you feel that that'll get the work done, do you want to announce? You want to hold?
Well, I'll wait to work with I'll go ahead and announce, Mr. President, if I may, your number one committee will meet Wednesday morning at 9 a.m. to hear House Bill 6, statutory theft amendments. Mr. President, thank you.
Okay, thank you. Senator Baldwin, Chairman Baldwin.
Thank you, Mr. Chairman. I'll go ahead and get this announcement out of the way. Your Perfect 10 Committee, Labor, Health, and Social Services, Wednesday morning at 8 a.m. to hear House 4 Mental Health Professions Practice Act amendments and Senate File 52 Insurance, Mental Health, and Substance Use Parity.
All right, thank you. All right, those trying harder and some already at a perfect 10. Senator Rothfuss and then to Senator Perkins.
Thank you, Mr. President. Mr. President, as far as the logistics, when is our last day of Committee of the Whole? I believe it's Wednesday. Is that accurate, that if we have bills coming out in the morning and did Committee of the Whole?
Correct and confirmed by the floor leader.
Is that accurate?
That is accurate. Sorry,
Okay.
Ellen can correct me if I'm wrong, but I'm pretty sure that is accurate.
Okay, thank you, Mr. Chairman. So as we contemplate working through the bills, that's good to know. And Mr. Chairman, or Mr. President, the request I'd make is if we have a Committee of the Whole concept for tomorrow, that we can get the bills, at least some preliminary ones, whatever the first 5 or so that we're going to work, and get those out this evening, so that we can prep those bills and everybody can read through those early. I know I would appreciate getting that head start tonight. So I'd make that ask before we adjourn. Thank you.
Mr. President.
Chairman Case.
Getting the notice out about Committee of the Whole or letting the public know is pretty essential. You know, in the old days, we had a board in here that said today's actions and tomorrow's action. It was put up at the end of the day. That gave the public the notice of how they did it. It's moved to the electronic world, but the public wants to participate as well. So, and they, you know, I think it's only fair to tell them what's coming down the pipe.
Chairman Case is correct. Before we move forward, let me, Chairman Ellis, I'm coming to you. Floor Leader Driscoll, let's make sure that Senator Case brings up a good point, public. That's one of the reasons I repeat often what we're working on, what we're debating, just so the general public can be aware where we are in the process. Go ahead, Floor Leader.
President, I will be around until we get those reported back to us. We've kind of had a drag on getting reported, but I will do my best to have those out for you tonight.
That work for everyone? I missed that whiteboard. I enjoyed working with that. Chairman Ellis.
Thank you, Mr. President. If the good chairwoman of judiciary would just reiterate which bill she's hearing. I think she said House Bill 6, which passed. So just a clarification on which bill the Judiciary Committee is going to hear.
All right. Follow up, Chairman Undercon.
Mr. President, thank you so much. It is House Bill 35.
Correct, and I missed that. Thank you for the catch. Okay. All right, Chairman Perkins.
Mr. President, can I have privilege of the floor just for a moment?
Please do.
Thank you, Mr. Chairman. I have the great honor to be on the invitation list to Senator Coe's memorial and funeral service on Saturday in Cody. It was in true Hank Coe fashion. Lots of stories from the family, from our former Senator and Senate President Eli Bebout, from the governor and others. Truly great. It's obvious that Hank Coe had a lifetime of service to the state of Wyoming, particularly for his community in Park County and thereabouts. Beautiful. He, having been a firefighter for 25 years, the volunteer fire department, the Cody Fire Department were there and gave him a great send off. He got a final ride in an old fire engine out to the cemetery, and lots of great stories about Senator Coe. It would have been great if, in a pre-COVID world, if we all could have been there. It just wasn't the case, but I know he was there. I know he felt all of your prayers and all of your well wishes and spirit, and the family was very grateful and recognized how much he loved the Senate and his fellow senators and legislators. And I just thought I'd share that with you. Weather was pretty darn good, and just a great send off. So thank you, Mr. President.
Thank you. Appreciate that report. Thank you. All right. Anything else? Let's just make sure we do the motion again, just for the good of the order. You've heard the motion. All those in favor say aye. Those opposed?
No.
You're overridden. The Senate shall stand adjourned until 10 a.m. Tuesday, February 2nd, 2021. Thank you, everyone, for your patience as we sort it all out.